Good morning. We are on the record at 9:21 a.m. on May 20th, 2016. This is the video recorded deposition of Edward L. Clark, DVM. My name is Scott Tanaka, here with our court reporter, Anella Sheridan. We're here from Veritex Legal Services at the request of counsel for the defendant. Today's deposition is being held at 550 West C Street, Suite 800, San Diego, California, 92101. The caption of this case is in the matter of the 2007 wildfire individual litigation, Witch Creek Cojito fires. Case number is 37-2009-00100-821-CU-PO-CTL. Please note that audio and video recording will take place unless all parties agree to go off the record. Microphones are sensitive and may pick up whispers, private conversations, and cellular interference. I'm not related to any party's action, nor am I financially interested in the outcome in any way. If there are any objections to proceeding, please state them at the time of your appearance, beginning with the noticing attorney.
Colin Vandell of Quinn Emanuel for defendant SDG&E.
Edward Leroy Clark, expert for Dr. Ross.
Christine Ross, DVM, plaintiff.
Court reporter, please swear in the witness.
Dr. Please raise your right hand. Do you solemnly state the testimony that you have to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning.
Good morning.
Could you please state and spell your name for the record?
Edward L. Clark, Jr., EDWARD, CLARK.
And what's your home address, Mr. Clark?
17061 Bolero Lane, BOLERO, in Huntington Beach, California, 92649.
Thank you. As an initial matter, this deposition of Mr. Clark is made in connection with the damages-only trial in this action, which is focused exclusively on Dr. Ross's claimed damages as a result of the 2007 San Diego wildfires. In other words, the damages-only trial will involve a determination of the type and extent of damages incurred by Dr. Ross in the 2007 San Diego wildfires, such as specific personal property damages. Causation and liability-related issues are not at issue in the upcoming damages-only trial. Therefore, SDG&E objects to any testimony by Mr. Clark at this deposition regarding non-damages related issues, such as claimed causation and liability. SDG&E also reserves all rights to depose Mr. Clark at a subsequent time regarding non-damages related issues. Mr. Clark, have you ever had your deposition taken before?
Yes, I have.
Okay. Have you had a chance to meet with anyone to go over the rules of deposition procedure?
It's not necessary. I've had my deposition taken many, many times.
Okay. Approximately how many times?
I'm guessing in excess of 100, maybe 150. That's a rough estimate.
Okay. Don't guess. One of the basic rules of deposition procedure. Please give us your best estimate, but don't guess.
Absolutely.
When we're going
It's
forward.
a rough estimate.
Okay. Mr. Clark, is there any reason why you cannot give your best testimony today?
No.
Did you meet with anyone to prepare for this deposition?
One meeting with Dr. Ross this past week.
What day was that?
I believe it was Thursday.
Did you meet in person?
Yes.
Where did you meet?
At a restaurant.
What restaurant?
I don't recall the name of it. It was next to the racetrack.
In Del Mar?
Yes.
What did you discuss at the meeting?
Her damages and relating to this trial, to this deposition today.
Okay. More specifically, what did you discuss?
We just reviewed the rules of the deposition. We talked about my expertise as a forensic electrical testing expert. We talked about my opinions regarding this deposition that I was going to present to you today, and we talked about all aspects of her damages.
Okay. When you're talking about all aspects of Dr. Ross's damages, what do you mean by that?
Well, she has damages that pertain to her lost personal property, her damages that pertain to her, the ability for her not to perform her business, the punitive damages that will be assessed based on SDG&E's actions. Her nuisance claim, I reviewed with her that she meets all the elements for the nuisance claim based on SDG&E's faults. Overall, that was about it. It was approximately about an hour-long meeting.
Prior to the meeting that you had with Dr. Ross last week, had you discussed this case with Dr. Ross?
On many occasions on the telephone.
Okay. What did you discuss on those occasions?
We discussed that again, just reiterated a lot of what we did. We went back over this last week. It was about testifying for her as an expert. She questioned my background as an expert to see if it was a fit for this case for her. She reviewed with me the history that I've had with this case and how many people have tried to retain me when my deposition has been noticed and you guys have squashed it. We've reviewed those kinds of issues leading up to the events.
What type of expert did Dr. Ross indicate to you she was looking for?
Well, and for this deposition, a damage expert as it relates to electrical related issues. So
explain that.
Well, for example, her line of work is as a doctor in the veterinary industry, and she specializes in evaluating and predicting potential failures in horses. Very, very similar to my background in the electrical world, and this is what I explained to her, that in the electrical world, my first company started out just like what she's doing, in the sense that I specialize in high voltage testing of equipment. The data I obtain is almost identical to the data that she obtains. So, you know, as I indicated to her, the analysis is more like, the value in her company, in my opinion, is not the person that actually physically performs a test. It's like you go get an EKG, for example, at a doctor. You have a technician that does the EKG, but yet a doctor evaluates the results. Very similar to what Dr. Ross does in her organization, very similar to what I do in my organization. So from a comparison standpoint, and as an expert for her, I shared with her that I felt very confident that I could, review this case, talk very knowledgeably about the effects of SDG&E destroying her database so that she no longer has that database required to assess testing done, even if it's done by others, not necessarily by her. I surely understand the impact of her business. I surely understand the diagnostics that she does, and I surely understand the history behind the value of the data obtained that cannot be recovered. So those are the types of conversations that I had with her and sharing with her that I thought I could represent her well as her expert.
How do you understand the history of the data that Dr. Ross has performed?
Well, I'm going to compare to what I do for a living, because it's exactly the same. In the electrical world, and electrical testing is electrical testing, whether it be on an animal, like a horse, whether it be on a human, whether you see HRV tests done on professional athletes all the time now, whether it be done on electrical equipment. The data itself is the same. For example, in power factor insulation tests, which your client's very well aware of what I do. Power factor insulation testing, you do particular testing to see how a particular transformer is performing. You test a particular transformer to see if you can predict if it's going towards failure or if you can keep running it hard, no difference than a horse. So when I understand the data, those decisions I make, for example, when I worked for the Edison company and my own company doing the exact same testing, I would send my technicians that worked for me out to run these tests. But they didn't have the authority or the knowledge or the understanding of how to assess whether that transformer is going to fail or not. That came to me. And what did I use all my past data for? To make comparisons on how this transformer was performing compared to a similar transformer. And that historical data, without it, I can't do my job, nor could I provide that service for somebody. Exactly the same situation that Dr. Ross has been faced with as a result of your client's actions.
Did you review any documents in preparation for this deposition?
Yes.
Which documents?
I have put together a set of documents for you with copies for everybody. I have put together all of the documents that I have brought today go directly towards damages. I have 2 binders that with a table of contents that contain tabs 1 through 50, but I think I only went up through 47. So tabs 1 through 47. I will give you these.
Let's first mark exhibit number 4253. Mr. Clark, if you could please take a look at exhibit number 4253.
Okay.
Exhibit number 4253 says on the front of it, San Diego Gas and Electric Company's notice of deposition of Edward Clark. Exhibit 1 of the notice of deposition is entitled Deposition Subpoena for Personal Appearance and Production of Documents and Things. Mr. Clark, have you seen this document before?
Yes, I have.
Okay. When did you see this document?
When you guys served me, I think last week or so.
Okay.
Whatever date you served me.
The deposition subpoena that's attached as Exhibit 1 to this document was served on you on May 6th, 2016. Does that sound right?
That sounds approximately correct, yes.
USA National Title Company accepted service on your behalf?
Yes, I'm the CEO of that company.
Did you review the request for production of documents in the subpoena?
Yes, I did.
Did you search for those requested documents?
Yes, I did.
Okay. What did you do to search for the requested documents?
I went through the request. I had been, as you most likely are aware of, been involved with this case since the inception, when I say this case, the wildfires with a variety of people since 2007. So I have kept a variety of documents over the years that are direct responsive to your testimony or to your subpoena. And then once I looked at some stuff that I didn't have documented or had put together yet that were in my possession involving Dr. Ross and some of the basis for my opinions today, I added those to my list of documents, and I spent this week putting binders together.
Okay. What were the original documents that you had that were responsive to the subpoena?
Well,
you can describe them in summary form right now.
They're documents that will most all the documents in here will go towards punitive damages for Dr. Ross as it pertains to SDG&E's intentional destruction of evidence and hiding the fact of what really caused the Witch Creek fire. So although you don't want to talk about causation, a lot of the documents are parallel because although they come down to the acts of SDG&E and how a jury or a judge is going to determine punitive damages for Dr. Ross based on the extent of those actions and quite honestly how malicious and intentional they were.
Would those documents that have to do with causation, in your view, have anything to do with damages other than punitive damages?
Yes.
In what way?
Well, the causation of the fire, Dr. Ross can no longer live in her home. It got burned down. I've got pictures of her son standing out in front of a completely burned down house. So the one thing that we know that's a fact in this case is that her home got 100% burned down and she lost 100% of her belongings that were in that home. So all of those documents and the one thing there's not a dispute is that SDG&E has accepted responsibility for its lines starting the Witch Creek fire. The way that got started might be in dispute between you and I or me and SDG&E, which is obvious, but in terms of the fact that SDG&E has accepted responsibility and it's been well published that their line started these fires, she no longer has the ability to enjoy her home. So those are directly related, all of the information is directly related to the damages associated with her personal property, directly relates to her losing all of her professional databases required for her to do a living, the damages directly related to her personal injuries that she's experiencing with stress and PTSD, the medical conditions that she's had, with everything she's had to go through as a result of losing everything she owns. So all of these documents are on point and directly reflect why she's gone through what she's gone through and who's at fault.
How do they directly relate to the specific damages that Dr. Ross has incurred?
Because the fire was caused by the utility. So the damages that she incurred, and again, they were caused by the utility. The fact is, this fire should have never happened. The fact that I think 16 more people got killed in the Witch Creek fire is devastating, knowing the fact that SDG&E knew they had a problem ahead of time and tried to conceal it clear back in 2003 when I think close to 25 other people got killed. So the malicious nature of this case is it's imperative that all the documents that I have go on point to SDG&E's actions towards damages toward Dr. Ross, not just her direct losses from a personal injury standpoint or her personal asset standpoint, but her direct losses relating to a personal injury standpoint, and also punitive damages both from a malicious standpoint and just on the sense that she meets the criteria on her nuisance cause of action as far as the jury instructions go, as far as meeting all the different elements.
Let's talk about personal property. Do the documents you're producing today have anything to do with the specific personal property that Dr. Ross allegedly lost in the fire?
Yes, it does.
How so?
Well, I have an outline of the personal property that was actually previously submitted in her mediation brief that outlines her personal property and her claim for what the value of that personal property is.
Okay. Is there anything else in your production that relates to personal property?
Yes.
And what would that be?
Everything associated with these documents, as far as I'm concerned, relates to personal property.
Okay. In what way?
It's the, in order for there to be a damages associated with personal property, there has to be a reason for the personal property, and there has to be intent on the part of, well, let me back up a minute. All the documents that I have go directly towards the damages that I cited already: personal property, personal injury damages, damages associated with personal injury, medical bills, all that stuff, and punitive damages. And the reason it's for damages to be understood, you have to understand the entire way we got there. So that's how they're all tied together.
When you say you have to understand the entire way we got there, do you mean the cause of the 2007 fire, and specifically the Witch fire?
Well, not in this particular case, because I know your client has already accepted the responsibility for starting the Witch Creek fire. So I'm not here to talk about cause in any way today. You've already asked me not to, so I'm trying to accommodate you. So the fact that the fire got started by SDG&E's a design problem goes hand in hand with everything that I'm exercising here today. So none of these documents here, this is 100% the testimony I'm going to present at trial on why the damages are what they are. Not just why they are, but goes to the damages, and so that you understand the damages.
When you say so you can understand the damages, what do you mean by that?
Well, I've got a mediation brief in here from Dr. Ross that was presented that clearly outlines what she feels she lost as a result of these fires. That's pretty specific, okay?
So your intent is to testify about the mediation brief that was provided to you about damages?
What I am going to testify about is that I have reviewed what she has claimed for damages. I will agree to the fact that we know is that she lost 100% of her assets that were in her home, and based on my review of the documents, my testimony is that I agree with her claims that she has presented. I don't have any, I didn't see any, excuse me, I'm burping. I reviewed her document closely, and I didn't see anything that seemed out of line to me, or that I would do differently, or that I would claim differently. So my testimony is I agree with her damages. She did lose 100% of her belongings, and that's my testimony.
Okay. You did not specifically calculate Dr. Ross's alleged damages, correct?
I did actually go with a calculator and check to make sure the numbers looked like they were correct. I didn't see any mistakes.
Okay. In terms of looking at the prior reports that had been provided to you by Dr. Ross?
As I indicated, I went through the mediation brief since that was a court document that everybody was relying on. I utilized that document to make a determination if I thought her damages were reasonable or not, and I didn't see anything in those documents that I felt was unreasonable.
Okay. When did Dr. Ross provide you with documents?
When I met with her this last week is when I got the mediation brief from her.
Prior to last week, had Dr. Ross given you any documents?
No, we talked on the phone, and I really, at that point, her personal, those documents were just needed for me to do some looks to make sure that I agreed with what her assessment was. I spent more time prior to last week understanding her loss of her documents at home pertaining to her business, and assessing my background to her background, and quite honestly was amazed how similar our backgrounds are and what we do for a living. Although she deals with horses, I deal in the electrical world, it's almost identical. And so, I did some research on what she was doing for a living and compared it to what I do for a living, and drew some conclusions based on that, actually.
When did you do that research?
I did some this last couple of days just to refresh my memory, and I probably got online and did some research, a couple of different occasions last month, the month before. I've known Dr. Ross for a while now, so I've had some reason to get involved. I held off this week, quite honestly, to do too much. I spent the bulk of my time this week on her file as far as assessing damages, because quite honestly, every time my deposition has been noticed, you guys have gone to great lengths to try to keep it from happening. So I didn't want to spend the time or money for her and as my client until I knew this deposition was going to go forward.
You called me on May 6th to discuss the subpoena, correct?
I called you. I didn't call you. I returned a call. You made a request for me to call. And I didn't know what the reason was for. It wasn't to discuss the subpoena. I think it was for you to confirm that I received the subpoena, because I allowed my office to accept service for me. So it was not for the purposes of discussing the subpoena. You made a request for me to send you all my documents in advance, and I said, no, we'll do that on the record.
Okay. Why did you tell me that you would not produce documents in advance?
Because it's my work product, and I didn't have sets of documents to give you, and I was putting all this stuff together this week. So as a result of your concern for wanting to have time to make copies, I took the liberty of making you a copy so you didn't have to do that.
Okay. Do you recall, prior to the deposition today, I asked to see these documents before the deposition began?
I think in the memo you made a request to get them ahead of time.
No, I'm talking about the conversation you and I had before the deposition started today.
Oh, today, yes.
Okay. And you said that I could not look at the documents until after the deposition began, correct?
That's correct.
And why was that?
Well, quite honestly, I don't trust you. You're not your SDG&E has gone to amazing lengths to cover up the reason and the causation behind the Witch Creek fire. There's a whole lot of people involved with helping you do that. And so I was going to walk out of the room, and I didn't want you to go through my documents for fear of what would come up missing when I came back in here. So quite honestly, it has to do with I don't trust you as a lawyer or your firm or anybody that's representing SDG&E as a result of the way you've intentionally and maliciously kept these issues from the public and tried to squash it.
Okay. Have you and I met before?
No.
Okay. And what basis did you have for thinking that I would do something with the documents?
You work for SDG&E, and when I have, as I have been engaged with this since 2007, and I see the extent that SDG&E, the steps they have taken to cover up this story or this issue or the actual causation, understanding, quite honestly, that, and very much understanding why they're doing it. SDG&E has the same design problem that I have identified caused the 2003 Cedar and Paradise fire, where a lot of people got killed. I have documentation and understanding at SDG&E, and have talked to people that SDG&E knew about this design in 2003, didn't fix it then for the same reason they didn't fix it now, for fear of admitting guilt. And hence, as a result of them trying to hide the 8 ball, because, and the reason for it is they can't get a rate increase if they're negligent in a design problem that causes the destruction. Now you get to 2007, and unfortunately, the odds of it happening again were extremely rare. They rolled the dice, they lost, fire started, people got killed, hence here we are now. I have had many meetings with Larry Davis, specifically general counsel for SDG&E, showed him in person, had a private investigation with him, with Jennifer Betts, showed him exactly what the evidence was, because SDG&E was supposed to preserve the evidence, in which they have totally not done. And now, lo and behold, in 2014, 7 years later, SDG&E is still playing Russian roulette with the lives and the safety of the people in San Diego County. So I have a lot of reasons not to trust anybody associated with SDG&E, because I just cannot go along with what I feel is a corporate cover-up in which they tried to get me to do back when I was originally retained with this case.
If you could refer to exhibit number 4253, which we were talking about before. Go to the subpoena portion of that document. Are you there?
I better put my glasses on.
Then please turn to attachment 3.
Gotcha, okay.
And the instructions portion of attachment 3.
Okay.
Okay. Please refer to paragraph A. I'll read that aloud and then we can discuss it. The documents sought herein relate to damages allegedly incurred by Christine Ross as a result of the October 2007 wildfires in the San Diego area. The requests do not seek documents relating to liability-related issues, such as fire causation and the identity of impacting fires. Did I read that correctly?
Yes.
Okay. Did you follow that instruction when producing documents in response to this subpoena?
Yes, I did.
Okay. How so?
I produced documents. All the documents in my possession here today are directly related to the damages.
Do the documents that you're producing today relate to causation of the October 2007 wildfires in San Diego?
The documents I have here today are associated with the 2007 Witch Creek fire. The documents that I have are related, they go hand in hand with damages as well as causation. So when you, and the reason why the damages are such that you have damages are, let me just make sure I understand what you're looking at. When you identify causation, you're talking about, there's no doubt a difference between what I know started the 2007 Witch Creek fire and what your client has basically acknowledged that started the fire. That's the two differences of causation that you're talking about. Is that correct?
I'm talking about the cause of any of the 2007 San Diego wildfires, regardless of what that cause was.
Your deposition is specific to the Witch Creek fire. So when you're trying to tie me down on causation,
no.
So I'm trying to get a definition from you on what you mean causation is, because are you talking about my definition of what I say caused the Witch Creek fire, which is obvious in documents I've provided to SDG&E, Or are you talking about where the lines came together? If that's what you're talking about as causation, is that what you're talking about?
My questioning has to do with any of the 2007 San Diego wildfires that you or Dr. Ross contends impacted her home. Could be the Witch Fire, could be the Wajito Fire, whatever you contend impacted Dr. Ross's home. And as I made clear at the beginning of the deposition, this upcoming damages-only trial has only to do with Dr. Ross's specific damages. That's it. Nothing in terms of the alleged causation of any of the fires that then subsequently allegedly impacted Dr. Ross's personal property or any other of her items.
That because we don't, I am entitled to punitive damages.
I understand what you're asking, and the answer to your question is yes. I mean, no, I am not talking about causation of whether it's SDG&E's admission or mine. We're not talking about causation today.
That's not my question. My question is, do any of the documents that you are producing today have anything to do with causation of any of the 2007 San Diego wildfires?
I'm not going to say not specifically. The documents, the interpretation of causation is in here. But again, the documents that I have here that could be alluded to that for that reason are also for damages specifically.
Okay. What do you mean by the interpretation of causation?
Well, there's no doubt what started the Witch Creek Fire is easy to identify, and pictures of where it started is in here. How it started is in here. Okay? And there's documents that relate to that, but those exact same documents also are documents that go directly to damages. And
How
that's
so?
Because the willful intent of SDG&E to make decisions and take actions with complete disregard for public safety is the reason there is a causation to begin with. So the documents that I'm referring to are relating specifically to specific knowledge SDG&E had and failed to act on. The cause of the fires are, at this point, irrelevant. The fires happened. We're not talking about causation. I'm testifying about the damages caused specifically by Larry Davis, the executives of SDG&E and Sempra Energy, the knowledge they had and the acts they failed to take, the things that they failed to do, which resulted in there being a causation of the fires to begin with.
Do the documents you're producing today cover in any way the identity of any alleged damages that Dr. Ross had in the fire?
Yes.
How so?
The damages are I've identified the injury, the personal damages related that she claimed in her intermediation brief that I already testified to, that I agree with, that I don't see any reason that it's wrong or misleading or lying or anything like that. And every document in here goes towards that issue. So when I talk about damages, I'm talking about it's not a specific area. All of my documents here are been utilized for me to draw the conclusions that I'm drawing that allow me to agree with all the damages and assess what the value of those damages are or should be or what they may be from a jury when punitive damages are assessed.
Have you independently come up with any damages numbers in your evaluation of Dr. Ross's case?
Yes.
What are those numbers?
They're equivalent to 100% of her personal injuries that she accrues from doctors, etc. It is a 100% of her personal assets that she lost at home, and the damages associated with her loss of revenue going forward. I agree with the numbers that she put down, so I agree with those numbers. So the specific damages numbers that I came up with are exactly what she has claimed in this case because I agree with them. So that's my independent analysis.
What are those amounts?
It's 100% of them. I can go through them with you if you like.
Let's mark all of these documents you're producing here today as exhibit number 4254.
Now, there's one for you and there's one for the court reporter. So how would you want to do
And
that?
let's go off the record so that we can arrange this.
Okay.
Thank you.
Going off the
Can-
record?
Can we arrange this on the record, please? Can we arrange this on the record, please?
You want
I'd
to go?
like to absolutely stay on the record, please.
Okay, back on the record. Okay, on the record, Dr. Ross has requested that we go through these documents on the record. So that's what we'll do. Mr. Clark, what are we looking at in terms of these binders?
You're looking at 2 volumes, tabs 1 through 50. Not all the tabs were used. There is a table of contents that outlines what's under each, the source of the documents, what's under each tab. And I've made 4 what I believe are identical copies. One for the court reporter, one for opposing counsel, one for Dr. Ross, and one for myself.
All right. Dr. Ross, I'm going to look through these materials and I'm going to go off the record to do that. I'm not going to say anything until I'm ready to go back on.
Sounds good.
Off the record.
Going off the record, the time is 9:57 a.m. Back on the record, the time is 10:13 a.m.
Mr. Clark,
Excuse me, counsel, I would just like to make one request. Rather than a blanket objection, if you would please object to each and everything you're objecting to, so I can know what exactly what your objections are, so I can keep track of those. If you have an objection to a specific document or something, I'd like you to raise it at the time so I'm aware of what you're objecting
okay.
to.
As I said at the beginning, in terms of any testimony that's made today with respect to causation, liability, we've made that objection at the beginning. I'm not going to continue to say that time and time again during this deposition. But if there are certain times, if you're doing questioning after that are specific instances where an objection is warranted, I'll make that objection. But in terms of issues related to causation, liability, it's our position that that is inundated throughout Mr. Clark's testimony in this case. So I'm not going to do that before the response to every single question here.
You refuse to do that.
I'm not going to do that. It would be a complete waste of time. Okay,
Can we
let's
go-
resume questioning.
Let's go off the record for a second. Let me talk to you just for 2 seconds. Go off the record for a second.
Okay.
Going off the record, the time is 10:15 a.m. Back on the record, the time is 10:17 a.m.
Okay, counsel, for the record, if you have an objection to a specific document, I would like you to notify me that you are raising an objection to a specific document so I can know what it is you're objecting to.
I've already responded to that. Let's resume the deposition. Mr. Clark, you just went out of the room to have a conversation with Dr. Ross, correct?
Yes, I did.
Okay. What did you discuss?
Her objection to that she tried to put on the record. You know, she's not an attorney, and you know you made a blanket objection at the beginning of this. It's difficult for her or her counsel going forward to understand what your objections are going forward for purposes of motions in limine at trial down the road, and therefore those issues should be held until then. If there's any reasons that you don't like something that's being said, she needs a record of exactly what you're objecting to. A blanket objection doesn't account for the entire book of documents. So she's not an attorney, so we just had a discussion because she asked me about that prior to on how I get that on the record. So I told her because I happen to know how to do it. So I expressed to her that she should, not let you push her around and just start the deposition without making a record and placing her objections on the record, so that if in need be, a judge can evaluate that and understand that you've made a blanket statement that she has no idea what that means going forward as you continue the deposition.
Did you tell Dr. Ross anything else?
Nope, that was it.
What did Dr. Ross tell you during the conversation you just had?
She just looked at me. She just looked at me and said, "Well, that's what I didn't. Isn't that what I said?" And I said, "No."
Okay.
So I go, so I know what she was trying to say, and then she's very nervous today, and you're not giving her much of a chance to put anything on the record. So, you know, I just said, calm down, be calm. You can do this. She's having a tough time today.
Did you say anything else to her?
No.
Did Dr. Ross say anything else to you?
No.
You also had a conversation with Dr. Ross immediately prior to the beginning of the deposition today, correct?
Yes.
Approximately how long did that last?
We walked out into the hallway, a few minutes, not very long.
What was discussed then?
She was obviously extremely nervous and shaking, and I was trying to calm her down, and I said, you'll get through this, you'll be fine. Just come in and sit in, and you'll be fine.
Did you tell her anything else?
No.
Did Dr. Ross say anything to you at that time?
She just said, I think she made the statement, she was, I'll get through this, I'll be fine.
Okay. Did she,
Something to that effect.
did she say anything else?
No.
Let's now look at exhibit number 4254, which is your production in response to the deposition subpoena.
Okay.
Am I correct that this production is included in two binders, each of which has documents in them?
Yes.
Am I correct that there are 47 different exhibits in this production?
I think if you look at the table of contents at number 45, it's blank. So there's technically 46.
What did you do to assemble this production?
I looked at your request for subpoena, and I pulled out everything that I could find that I thought was responsive to your subpoena, and I put it all out on the floor and proceeded to put these books together.
Okay. Is it your position that all of the documents in these binders are responsive to the subpoena?
Yes.
Are there any documents that you have that were responsive to the subpoena but are not included in these binders?
Not that I'm aware of. I did my best efforts to identify and look at everything I had in my possession and include them.
Okay. So to the best of your knowledge, everything that is responsive that you have is included in these binders?
Yes.
Which documents that are included in these binders did Dr. Ross provide to you?
I will point out one other thing that's not in these binders, because it was just, I looked at your one request for emails and not disconnect attachments. So I printed this out last night, which is just a set of emails with documents that, those are the email correspondence that I got from her. And
So
those are in addition to these documents. Okay, I mean, that's, a lot of those same documents are in here, but the way your subpoena read, you didn't want them disconnected, so I provided it to you in that fashion.
So to clarify, and let's first mark this as exhibit number 4255. To clarify, are the documents that are included in exhibit number 4255 each replicated in exhibit number 4254?
I believe they are. Yeah, I mean, I went through and you know, when I received those emails, I'm sure I pulled out just the attachments and didn't have the emails attached as you asked for. So, to my knowledge, all of that is in the binders.
Okay. How did it come about to collect the exhibits in exhibit number 4255?
In that one?
Yes.
Actually, I was just reviewing one last time, your subpoena, and I saw your statement in there, don't disconnect attachments. And so I went back and tried to accommodate you.
Thank you. So now going back to the question I had about the exhibits that are included in exhibit number 4254, could you please identify which of the exhibits in these binders Dr. Ross produced to you?
If you would like me to take some time and go through, I'm sure they're spread out because I didn't put anything in here in any given order.
I believe that in the binders that you have provided to us, there's a table of contents at the beginning.
Yeah. Okay, I can go through that. Let me do that. Where'd my glasses go? There they are. When you say Dr. Ross, are you including counsel, like when she was retained, when she was represented by Chavos and Ra?
Counsel as well, but if
Okay.
it was her counsel, please let me know if it was
Okay.
her counsel.
37 was the retainer by Chavos and Ra.
Let's start with that. If you could turn to exhibit number 37. Exhibit number 37 is an email from you to Anthony Chavos, correct?
Yes.
It's dated September 10th, 2015.
Yes.
Do you recall sending this email?
Yes.
Let me just read the email. It's very brief. Mr. Chavos, please be advised that this email shall confirm that I have waived the $3,000 retainer, as I have already determined the cause of the 2007 Witch Creek fire and no further work is required prior to my deposition being taken. My hourly rate for deposition is $450 per hour. Did I read that correctly?
Yes.
What led to this email that you sent?
Mr. Chavos had contacted me prior to this letter, and in fact, I think there was a deposition notice by Chavos and Ra probably earlier that I missed. I should probably point that out to you, where I would believe I was going to be deposed. He asked me if I was opposed to deposition, just to find out what I knew, because I've been involved with this for so long. I said, no, that's fine. So a deposition notice went out, and you guys successfully quashed that deposition and didn't allow it to go forward. And then later, you got back on the phone and asked me if I would, consider being designated expert for Dr. Ross, and I said sure, and that's what prompted this letter. Regarding the cause, if you will, versus that part of it, I've been involved with this case since 2007, so there was no sense in, I didn't have to go back and reinvent the wheel and understand what this case was about and why she suffered the losses that she suffered. So I waived the retainer agreement.
When were you retained as an expert by Dr. Ross?
As a result of, I think the day before, he called me the day before. When I sent this to him, he contacted me, I think, the day before, and we talked about actually being an expert.
So to the best of your recollection, you were retained as an expert by Dr. Ross on September 9th, 2015?
Yes.
Which was the day,
roughly that general area.
which was the day before this email was sent?
Prior to this, I had been in contact with her attorney at the time, and there was discussion of, about my knowledge and just general conversations, and if I would consider being, would I be opposed to being deposed? I said absolutely not. So the being an expert wasn't done until this point.
Okay.
A designated expert, I should say.
Okay. Other than this email that you sent to Mr. Chavos, do you have any written agreement reflecting your retention as a retained expert for Dr. Ross?
My standard in cares, I rarely don't have a written agreement. It's done by just sending once they get a copy of my CV and my rate sheet. On my rate sheet, in fact, it's tied to this, and quite honestly, I don't know if I got a signed copy back from Tony or not. If I did, I didn't look for it, and might not. So there might be another document I can send you that's got a signed copy from Mr. Chavos. That's not something I keep in my file, so I didn't think to go look for that.
Okay. Can you look for it after this deposition?
Well, wouldn't have it here, but after a different day, I can go check to see if I have that. And if I do, I will forward it to Dr. Ross, and she can then forward it to you.
Okay. When did you first speak with Mr. Chavos?
I don't recall, quite honestly. I don't know. I don't know when he got involved with Dr. Ross on this case.
To the best of your recollection, when did you have your first communication with him?
I will estimate several months. Not quite sure when he got involved with Dr. Ross and when we first started talking about it.
When you estimate several months, do you mean several months before this September 10th, 2015 email?
Yes, because he had contacted me to ask me about what I knew about the causation. I knew Mr. Chavos prior to him representing Dr. Ross. Back when this first all started, he was I forget exactly what he was going to do. I was trying to look for, I don't recall what the relationship was, but his name was out there looking for people who had been damaged by the Witch Creek fire. And so there was some, and I don't know exactly what those dates were, but back in 2007, so he was aware of the 2007 fires. I don't think he knew Dr. Ross back then. But so that was when you say when was the first time I talked to him, we talked about this fire way back in probably early 2008. I'm assuming, I'm estimating the time frame. Okay. And there was something going on back then. I don't really recall all the details. And then, he was out of the picture, and I don't think he had anything to do with anybody at that time. And then later on, he got involved with Dr. Ross.
What were you retained as an expert in this case to offer an opinion on?
Our discussions on the phone originally were to obviously assess causation, assess damage, and damage on several fronts. So he asked me what.
Let's first take it step by step.
Sure.
With causation,
sure.
What were you retained to offer an opinion on?
What caused the Witch Creek fire, and my experience and knowledge of San Diego Gas and Electric, its attorneys and its executives, as well as CAL FIRE and the Public Utilities Commission, avoiding the finding of facts that caused this particular fire.
Okay. Were you retained to offer an opinion on anything else?
Well, when you say anything else, I think I was pretty specific. I mean, the retention involved a lot of elements because I'm been involved with so many people at so many different levels on this, what I consider a corporate cover-up by SDG&E. And so he was very interested in all the elements that I knew. So okay. When you say, was I retained, we talked about a lot of things. I can't really pinpoint one specific thing other than the fact that there was no doubt causation was one. My communications and the cover-up by the executives of SDG&E was to the cover-up, my communications and failure for the Public Utilities Commission to notify the public in their public record that they presented, the notifications and communications I had with CAL FIRE, and the denial of the investigator that I met with who prosecuted the lost, I'll say falsely prosecuted the lost hunter for the 2003 Cedar fire. I shared discussions with him regarding the meeting I had with all the fire captains and CAL FIRE in San Diego, and the fact that the two people taking minutes were on an advisory board for SDG&E.
Okay.
So all of those opinions, you asked me what all we talked about, so I'm trying to get it all out there for you. I don't want to miss anything. So there are we talked about the fact that the PUC came out to an investigation with me, and he asked me to offer an opinion on why I thought the PUC didn't do anything about it. But I shared with him that I met with the PUC on site, and Steve Untably 100% agreed with me where the fire started, 100% agreed with me that there was arcing. He confirmed his findings with me with Jeff McDonald of the Union Tribune on the telephone, and then following that day, the PUC wouldn't let him talk to us on the telephone. we talked exclusively about the meeting that I had with
Right. Let's
Jim Barrett.
focus on
But-
exactly, no, this is the question, though, is what you were exactly retained to opine on. You
Well-
said causation.
well,
Was
you're-
there any other issue? You've been talking about causation issues. Any other issue that you were retained to opine on in this
Well,
case?
I was building up, but you cut me off, so it's all part of it, Counsel. So let me finish. All of this goes hand in hand to understand damages and the state of mind of SDG&E and what was trying to be accomplished. Okay, so I was retained to offer an opinion on why the public utilities did not want to know what really started the Witch Creek fire. I was asked to offer an opinion on why I thought, especially with my history with Larry Davis as an expert for Sempra Energy, why Larry Davis failed to have a meeting and refused to have a meeting with CAL FIRE and the PUC with me in the room to tie down the reasons why the Witch Creek fire started. So all of those elements are things that Mr. Chavos asked me, would you be willing to testify to those as our expert and offer opinions on your reasons why they wouldn't come together? And he asked me what my reasons were and what I would testify to. And what I told him was that you have a fire that was started in 2003. The Cedar and Paradise fire started at the exact same time by the exact same design problem that started the Witch Creek fire. I told him the problem you have is you had a lot of people get killed in those fires, and there was a lost hunter that was identified as, and in my opinion, was a fall guy and falsely prosecuted to get the utility off the hook. And the reason why they didn't fix the problem is because if they go out and fix the problem, and I've got evidence and testimony from people that knows that I knew that they knew what caused those fires, that they wouldn't be able to get a rate increase through the PUC. So they played Russian roulette and didn't fix the problem for fear of admitting a guilt. Another fire started in 2007. Now it's double down. Now it's double the trouble. 14 more people got killed. Now, to me, which is on their hands, and they still didn't fix the problem. I had a meeting specifically with Larry Davis and 3 employees, a protection engineer, a senior executive, and a transmission engineer, showed them where the fire started, and as soon as they admitted to me that, oh my God, we're in deep shit, was, quote, the word used, Larry Davis stopped the meeting, wouldn't let anybody say a word until everybody exited the room. From that day forward, it's been a nightmare to talk to people. So I told them that's the reason this is all happening. So now you've got, the bigger problem is now they're trying to keep from getting their rate case denied on the Witch Creek fires. But the bigger problem is that there's no statute of limitation when people die and when you kill people. So now when the real truth comes out about what started the Witch Creek fire, somebody is going to go back and reopen the Cedar fire and the Paradise fire. So I think Sempra Energy and the other thing that I shared with him as part of my opinion and what I'll share is that throughout my work on this case, I have sent, and what's all in here, which goes towards state of mind and punitive damages, that all the Sempra Energy executives, all the SDG&E executives, all got email correspondence to me, from me, keeping them in the loop so that Sempra can't disassociate themselves from SDG&E. So those opinions are the opinions that Mr. Chavos asked me if, he goes, that's big time stuff. Are you willing to testify to that? And I said, absolutely. Sempra Energy and San Diego Gas and Electric, in my opinion, should be held accountable for the damages that they have brought onto people and the distress that they have brought onto people and the catastrophic destruction of property and business. So all of these documents, although clearly outline cause, also outline exclusively damages, state of mind from the executives, and the cover-up associated with it, and how it and why the decisions are being made. And to add to it, you've got Sempra Energy, Larry Davis, with people telling him this is a problem. In 2007, I go to job site with Jennifer Betts, accompanied by Larry Davis, only to see that they destroyed the evidence, all the yellow covers that are throughout this book, and the carbon deposits, gone, not in the evidence locker. And 7 years later, knowing that that started these fires, knowing that that design started the 2003 fires, they still haven't fixed the problem. And so that's what, all goes towards state of mind by the executives, what they're trying to do. And then there's a distribution list in here that outlines from the President of the United States to Vice President Biden to the head of Homeland Security to then Secretary of State Hillary Clinton to Governor Brown, or then Attorney General, now Governor. I've never understood why somebody in government didn't care. I've never understood why somebody in government didn't request a meeting. I just think I just discovered why. I think I finally learned about how powerful super PACs are. I just figured out that Governor Brown's sister is on the board of Semper Energy. So no wonder nobody in government will help me figure out and protect the people that live in San Diego County. Semper controls the government, just like we've been seeing in the news. And unfortunately, I don't know how that gets resolved, but that's a completely separate issue. But all of those issues go towards state of mind and punitive damages and malicious intent and failure to protect the public and breaching their fiduciary duty as a public utility. So those are the opinions, and those are things that I was very animate about that I would share with Anthony Chaffetz, and obviously I appreciate that you let me share it on video.
We've had somebody new that's joined the deposition over the past couple of minutes. If you could please identify yourself.
My name is Sally Grosna, plaintiff in this action.
Thank you, Ms. Grosno. Mr. Clark, if you could turn to the second page of Exhibit 37 in the binder we're looking at. Is that your resume?
CV, yes.
Okay. Is that a current version of your CV?
The only thing that is not on here is I'm also the CEO, Chief Executive Officer of a title insurance company, and I've just never added it to this particular CV for expert witness litigation because it's not relevant.
Okay. What is the name of that title company?
USA National Title Company, Incorporated.
Okay. Is the CV that we're looking at completely accurate?
To the best of Let me get my glasses on, take a minute and see if there's anything that needs to. I think it's accurate, and with the exception of, only because this is I'm testifying as a damage expert in this case, but I think damage expert falls under failure analysis, accident reconstruction. So I think the damage side of my testimony falls under those. So I think the way it's written is probably adequate.
Do you see anything in this CV that is incorrect?
I don't think so. If you want to point something out to me that you don't agree with.
Just asking you.
No.
Other than exhibit number 37, what other materials in your document production today have been provided to you by Dr. Ross's counsel or by Dr. Ross?
Okay, let me. Oh, number one, it was the deposition subpoena originally was sent to me from her counsel, Chavos and Raw.
The deposition subpoena that
Yeah.
was sent to you?
Yeah.
Okay, what else?
Okay. I told you 37, 38. Oh, that's sorry. That's something I sent to Mr. Chavos that wasn't provided by. So let me scratch 38. Number 41.
Number 41 is a mediation brief by Christine Ross, correct?
Yes.
It's entitled Plaintiff Christine Ross's Confidential Mediation Brief.
Yes.
Okay. Did Dr. Ross provide you with this document?
Yes.
When did she provide you with this document?
When I met with her last Thursday,
Why did she provide this document to you?
I asked her for it
Okay. Why did you ask her for it?
because I'm providing testimony on her damages, and I wanted to see what she was claiming, and I needed to evaluate them to see if I agreed with them or not agreed with them, to see that should I need to offer opinions based on that.
Did Dr. Ross agree to provide you with this document?
Yes.
Did Dr. Ross agree for you to include this document in your document production today?
I didn't ask her, no. So I can't answer that yes or no.
Okay. But you are including this document in your document production today?
Yes.
What does this document include in it?
Do you want me to go through each page, or do you want me
No,
just to give
that's
you a generic?
okay. So it appears that the beginning portion of the document includes a written description of Dr. Ross's alleged damages. Does that sound correct?
Yes.
And then after that, attached to the document is a mediation settlement demand, correct?
Correct.
Then after that is a document summarizing the type and value of alleged damages for Dr. Ross. Is that correct?
Correct.
Okay. That document is entitled Recapitulation on top.
Yes. Yes.
How did you factor this document into the analysis that you've performed in this case?
Well, the facts are. Oh, let me start and I'll lead up to this. Okay, if you bear with me, just if you go to. If you go to tab 44. first thing that I asked Dr. Ross that I needed to do is, number one, I needed to determine and see the structure. So I went to the internet and found the attached pictures under section 44, which is a picture of the news interviewing her son standing in front of her home.
To clarify, exhibit number 44 is an email from Dr. Ross to you, correct?
Correct.
Dated May 19th, 2016?
Correct.
Okay. Then below that is an email from you to Dr. Ross, correct?
Correct.
Also dated May 19th, 2016?
Correct.
You state in your email, Dr. Ross, please look at the attached picture and verify via email that this is your son in your old home. Is that right?
Correct. And the reason I did that, obviously, is I'm testifying as an expert and I need to do my due diligence and make an assessment of the amount of damage. So if you look at this, these pictures, anybody can look at these pictures and draw the exact same conclusion that I have, and even if they're not an expert, is that the house is a 100% loss. Hence, my conclusion on her damages, on her personal belongings, and the valuables that were inside the homes is that she has a 100% loss. So that's how I drew that conclusion. You can see it for yourself.
What was
Okay.
the address of Dr. Ross's property that was impacted in the fire?
I got to look at it. I have to look it up on a document. I don't remember it off the top of my head. I have it because I actually have it on my phone real quick because I went to the site.
What town was
can I
the
look?
property located in?
Rancho Santa Fe.
You said that you went to the site,
Yes.
correct? When
Yes.
did you go to the site?
Last Thursday when I met with Dr. Ross, prior to meeting with her, I just drove by just to see the site, see what it looks like today, and there's been a new home put on it, and it's all rebuilt now.
Before going to the site last week,
Yes.
had you ever been to that site before?
No, I had not. I used these pictures as the source of my determination that she has 100% loss.
What do you know about Dr. Ross's involvement in the 2007 San Diego wildfires?
I don't have any knowledge about her involvement in the wildfires themselves. I wasn't asked to offer an opinion on that issue. My opinion is based on her damages.
Okay. When's the first time that you ever had a communication with Dr. Ross?
I think I first spoke with Dr. Ross when I was working with Jennifer Betts. I think Jennifer Betts is who introduced me to Dr. Ross. She was another plaintiff in this case, and was doing a lot of work with her. And I think it was her that shared with me and introduced me to the two ladies to my right.
Meaning Christine Ross and Sally Krosno?
Yes.
Okay. When was that?
I'm estimating Jennifer Betts was, I think I was working with her back in 2014.
So approximately 2014 was when you were first introduced to Dr. Ross?
I wasn't introduced to her. She shared with me who they were. I don't think I met Dr. Ross or talked to her on the phone until she was, Mr. Chavos contacted me about her case. I don't recall ever talking with Dr. Ross prior to that.
Okay. When was the first time you communicated directly with Dr. Ross? Either via email or speaking in person or on the phone?
It'd be whatever the time frame is that Mr. Chavos was working on her case, it was sometime in that time frame.
With Mr. Chavos involved as well?
I don't recall. I don't recall if Mr. Chavos asked me to call her or if she called me. I really don't recall the details of that at this point.
Were you ever involved in communications involving you, Dr. Ross, and Mr. Chavos or someone from Mr. Chavos's firm?
I don't know if we had any conference calls or not. I don't really recall. Usually when I was speaking with Mr. Chabos, it was with Mr. Chabos, and I did have a couple conversations with Dr. Ross back at that time, and I don't really recall if it was with him or not. Honestly, I'd be guessing.
Going back now to Exhibit 41, the mediation brief, how did the mediation brief factor into your analysis in this case?
Well, since I'd already made the determination that she had 100% loss, and I'm testifying as her damage expert, I needed to get a background on what the basis was for her claims. I already understood the value of her loss, and without her sharing anything with me, just knowing about her losses from her business, being in the exact same boat as she is and understanding her business, it's virtually parallel to mine. I fully understood the value of that already, so I didn't need much from her regarding her business. So I really needed an outline of the belongings that she had in the house, and I asked her, how do I go about making a determination if somebody asked me, you know, if I agree with your findings or not. So that's why she provided me this document, so that I can have a basis of what she's claimed. And I looked through it, and I evaluated it, and I ran some calculations to see if it was, you know, if I found anything wrong with it. And I didn't see anything wrong with the claims made, and there's nothing in here that looks out of the ordinary, and so therefore I agree with her claim, because I agree with the fact that she lost everything she owns.
Other than looking at this mediation brief, did you do anything else in coming to the conclusion that Dr. Ross's demand for damages is, in your view, reasonable?
Oh, absolutely.
What else did you do?
I went back and pulled all of my documentation to this file, and with reference to punitive damages, I shared with her that, you know, the state of mind of the executives, their willful intent to breach their fiduciary duty to protect the public, their actions to keep me from being deposed and my information from being public, will all go towards punitive damages. So I shared with her that I have extensive damage analysis information to go towards that issue on point. And then with reference to her business, it really didn't take much talking to her for me to understand why her claims are what they are in her business, and the value of losing the database has on her as a doctor, and being able to assess her clients' horses based on data she no longer has and can't recreate. So from a damage standpoint, her business is parallel to mine. I understand it probably as well as she does, and I might say better. I've been in business for a long time. My testing background in electrical forensic work is far superior to, quite honestly, most people in the country. Hence, that's why Sempra's utilized me in the past. So I understand her testing and why she did it, and what they needed for the database and what she was trying to create, and being on the leading edge of an amazing industry for the horse industry. So for Sempra to come along and ruin that for her, and especially not take responsibility and trying to eliminate her as a plaintiff, you know, I think the truth will eventually come out at some point.
Okay. What is Dr. Ross's business that you're talking about?
She's a veterinarian. She's a veterinarian, and she created a huge database in testing racehorses and predicting fatigue, and trying to allow trainers, when you have these these horses that are thoroughbreds or what have you. She had a device to measure the heart rate, the pulse rate, the frequencies of them, the levels, and measure the stress of the horse, so that absolutely no different than what we're doing to humans, to human athletes, but she's taken it to the horse racing industry. And that kind of data and that kind of an analysis is only made with a lot of experience behind you. Anybody, and I don't mean to downplay this, but her business is not any different than mine. In testing high voltage transformers, I would send people out to do the test for me Do I know how to do them? Absolutely. But was I going to spend my time to go out and do it? No. So in her world, in her business, she could have trainers, people that she trains, technicians, if you will, like somebody taking your EKG. You have a technician at the doctor take your EKG. A doctor reads it, not the technician. The technician won't tell you anything because they don't know what they're looking at. They just know how to take the test. So her business and her loss and the value of her loss is really it's a jury question on what the total punitive damages could possibly be, because you can't really put a number on what her potential was with what she had at her disposal and what she had created.
What is it that is measured with Dr. Ross's testing equipment?
She calls it a heart rate variability, and all it is, it's an electrical display of what the horse's heart rate is, how high it goes, how low it goes, what the frequency of the heart rate is, and based on the history of the horse and the readings that she has, she's able to predict whether or not that horse is under stress or is under fatigue or is getting close to collapse. You go to a horse race today and you see a horse get put down at the racetrack. She had the ability, or was creating the ability, to predict that. So if you owned a $10 million horse or a $100 million horse and you just lost your ability to have that horse saved because Sempra Energy took that away, you can understand the value of what she's lost.
When did you first learn about heart rate variability?
Oh my goodness, I've been involved with it for quite a while. I think I do it myself, and you probably do it yourself. We all know what Fitbit is on our wrists. I train, I'm an athlete, I do 100-mile bike rides. I used to race motorcycles professionally when I was a kid, but in the last several years, anytime I train, anytime I go to the gym, I monitor my heart rate, I monitor my pulse. It's all measuring statistics so that we know if we are getting to the point of collapse. You're running or you're on a bike ride, and my heart rate, I'm 57 years old, I get up to a certain point and I know I need to slow down or back off because I'm pushing myself to collapse. That's exactly what she was doing, but for horses, different than humans. So I think, when did I first get involved? I think I've known of it for many years. That's what all these devices that you and I are seeing out in the public market today, we all know what they are. We all know why we're using them. It's so that we can all protect ourselves. And she has just taken that technology, the difference being is the results in a horse or an animal is different than that of a human. So that data takes many years to collect, so that, like when I'm doing a transformer and I have a data on a transformer, I can predict if that transformer is going into failure based on years of data in the industry. Without that data, that test isn't valid.
When did Dr. Ross start gathering HRV data?
I think it goes back like 8 or 9 years. I think she shared with me she lost about 9 years worth of data.
Okay. When did you learn about Dr. Ross's work with HRV?
I think Jennifer Betts first told me about her, about how she lost everything she owned in her house. She lost, all of her business, and she lost her whole history of work. And quite honestly, I didn't know I was going to be involved with her, so I didn't ask too much about it. But I did inquire about, what her business was, and I was just intrigued because it was so much like mine.
When did you first communicate with Dr. Ross or her attorneys regarding Dr. Ross's HRV work?
With Mr. Chavos. When Mr. Chavos called me and he explained to me what was going on with her, when he wanted to give me a deposition, and so I inquired a bit to him. We talked about what was it she lost, what's her, we talked a little bit about the case, but that's when I first kind of realized.
I need to raise an objection about the ruling on the Sargon motion and why you're pursuing this line of questioning regarding the ruling on the Sargon motion and testing. Why are you doing that? I have an objection to that.
You have an objection to asking about HRV?
You filed a motion.
Correct.
And
Correct.
what was the ruling on
Dr.
that motion?
Ross, you continue to assert claims regarding recreation of your HRV data. You also continue to assert claims regarding recreation of your alleged HRV testing equipment and software. This all has to do with
Wait,
that.
where are you? Okay, I object to that. I object to your what you're alleging.
Dr. Ross, are you saying that you no longer have HRV claims?
I'm not being questioned here. What I'm saying is you have raised a motion to eliminate testimony regarding specifically testing. And you are asking questions, and I am objecting to that, and we'll deal with that at some other time. I'm objecting to that.
Okay, let's continue with the deposition. Let's go back now to exhibit number 41, the mediation brief. If you could refer to the personal property list, which is included as exhibit B. Is it your testimony that you found this personal property list, including the contents of the list and the ultimate value reached of $2,661,279.88 to be reasonable?
I didn't see any reason to dispute it
Okay. Why is that?
because it's what she's claiming as the value of the items that she lost, and I don't have anything in my possession to rebut that or dispute that. That'll have to be a jury decision as to what, if they believe it or not. But to me, I don't have any reason not to believe it.
Did you look at any other documents other than this personal property list in concluding that you found this personal property list to be reasonable?
Yes.
What were those documents?
As I referred to the exhibit earlier regarding the pictures of her home being 100% destroyed, as I indicated, I first realized that and concluded that she had 100% loss.
Okay.
So that document led me to this document. And looking at the document, I have no other documents to dispute or any reason to not believe the document that is in front of me that this is a valid claim.
Okay. Other than the YouTube video of Dr. Ross's son in front of Dr. Ross's former home, did you look at any other documents or materials other than this personal property list and concluding that the personal property list is reasonable?
No, I did not.
Have you let's go to what else Dr. Ross has provided to you. If you could continue going down the table of contents list
Okay.
and identify anything.
What number did I leave off with?
The mediation brief was number 41.
Okay. She sent me a check, number 46.
Let's go to number 46. That's a check from you to Ed Clark, the electrical expert, correct?
No, that's a check from Christine Ross to Ed Clark, the electrical expert.
Dated.
No, you said it was from me to Ed Clark. It was from Christine Ross to Ed Clark, dated April 1st, 2016.
For $500?
Yes.
What was that check for?
I had I had provided her with a declaration and just to catch up on what I felt I had done for her up until that point. I had waived the retainer agreement. I hadn't spent much time on this case until, like I indicated earlier in my testimony, that I knew we were going to actually have a deposition. So up until this point, I haven't invoiced her yet for the work done this week. So up until the start of this week, that was what I felt was fair that she owed me. Based on $450 an hour, I haven't spent much time on this case for her up until that point.
How many hours total have you spent working for Dr. Ross on this case?
I spent this week, I worked all day Monday, part of Tuesday, all day Wednesday, all day yesterday.
Approximately how many hours
I'm
total?
going to say probably 30, 31-ish, somewhere in there.
What did that work involve?
Reviewing her outline of damages, doing some research on
When you say outline of damages, you mean the mediation brief?
the mediation brief, doing some research on making a determination that I understood that she had 100% loss at her home, so doing some research on the internet. I also did some research pertaining to CAL FIRE documents, some research concluding that Kathleen Brown is Governor Brown's sister that's on the board of Sempra Energy. I also did quite a bit of time putting all this stuff together for you folks here today. I did spend a lot of time going back, and I've been working on this since 2007, just to review my thoughts and processes regarding the state of mind of the executives of SDG&E and Sempra Energy. So that's pretty much involved. Once I realized I had a deposition, just concluding my thoughts on her damages overall.
Have you billed Dr. Ross for this work that you've done?
I have not yet. Like I indicated, I just did the work this week, and so once I see how long this deposition takes today, and how much you pay or don't pay, then I will generate the final bill and send it to her until she needs me again.
What will the bill be based on that you send to Dr. Ross?
$4.50 an hour per my CV that I gave you today.
How many hours?
It'll be, like I said, let's see, 24 times 3, let me think, 16. It'll be probably for about 30, 31 hours.
Approximately how much will that be in total?
Well, you got a calculator, Counselor. You can multiply it times $4.50 an hour for me.
Other than the check that we just looked at, that's Exhibit 46, did Dr. Ross or Dr. Ross's counsel provide you with any other documents in your production today?
I've got some stuff that let me go back and let me look to see if I have anything that I received. I provided Anthony Chavis some things, so that's in here. Do you want me to touch on those as well?
Let's first go with what was provided to you.
Let me see if I got anything from Tony. I don't think I got anything actually sent to me from Tony Chavos. Let me think here. Mediation resent. The subpoena I received from Anthony Chavos of Chavos and Raw.
Right.
That I did receive from him. I don't think there's anything else. I don't think I received anything from him because it was more him inquiring to me.
Did you receive anything else in your production from Dr. Ross?
I think I just went over the things that I got from Dr. Ross with you, didn't I? Isn't that what the last question was?
You said the mediation brief. Anything else? And the check.
And the check, I don't think so.
What about number 42, discovery on HRV, heart rate variability?
That was stuff that I looked up on the internet in my, just to kind of compare what she was doing to what I was doing, just to confirm what I already knew.
So to the best of your knowledge, we've already discussed all of the documents in your production that were provided to you by Christine Ross or her counsel.
Yes.
What were the documents included in this production that you gave to Dr. Ross or her counsel?
Now let's go back through this thing here. And when I think I'm going to talk about Mr. Chavos first. Obviously, I gave Mr. Chavos my CV, an acknowledgement that I would waive the retainer agreement. We spoke about that already. I think I gave Mr. Chavos a copy of the confidentiality agreement that SDG&E tried to get me to sign in order for me to share with them their design problem. And I expressed to him I wouldn't sign it.
That's Exhibit 5.
Number 5. I gave to Mr. Chavos a copy of the independent lab the lab report that proves that arcing exists at the point where the Witch Creek fire started, electrical arcing at ground level. Number 7, I think I gave to Mr. Chavos.
Okay.
I believe I gave to Mr. Chavos. I put a package together and just handed it to him. So I gave him a copy of number 8, a whole bunch of pictures of SDG&E poles, and number 8 is I provided this to Mr. Chavos, which is a pole on the SDG&E system with the exact same design, but with a variation that proves prior to the Witch Creek fire that they knew this design problem caused arcing at ground level and put the public in danger. So number 8 is a pole. I gave him a picture of a pole, and if it's in here, that was installed prior to the Witch Creek fire that shows that they'd already changed their design knowing that this design was in error, and they were intentionally not fixing it on the Witch Creek fire. I gave Mr. Chavos number 9, the design standard from Southern California Edison, the neighboring utility, exactly right on point, showing, identifying that the design was wrong. I gave Mr. Chavos the slideshow explaining how the fire started, presented to Mr. Davis. I gave him the information outlined in the meeting I had specifically with Mr. Davis and SDG&E employees at Sempra Energy headquarters, explaining to them and showing them physically how the fire started and proving it to them. I gave Mr. Chavos number 11 the correspondence with the Public Utilities Commission, which were meeting minutes that I had with the Public Utilities Commission following the meeting minutes that I created following a meeting I had in LA explaining to them what started the fires.
So is it fair to say that you gave Mr. Chavos several of the documents in here?
Well, please let me go through and just...
No, that's the question right now.
Well, there's still a question pending that I haven't finished, so I'd like to finish that question.
We don't need to finish it.
Okay, so...
We don't need to waste time finishing it.
Okay, that's fine. So
if it's fair to say that you agree that you gave Mr. Chavos several documents in here, that's fine enough for us.
Well, I don't want you to put words in my mouth, so what I will say, what is fair, is Mr. Chavos was given all the documents pertaining to the state of mind and the cover-up by San Diego Gas and Electric and Sempra Energy. So it is a fair statement to say that at the point he retained me, I tried to share with him what I knew about everything involved with this case.
Thank you. What documents did you specifically give to Dr. Ross?
I don't know that let me look to see, let me start back over again with number 1. I don't know that I gave anything directly to Dr. Ross. Let me look. I don't know that I gave anything directly to Dr. Ross because it was all done through her counsel at the time.
Okay. So to the best of your knowledge, You have not provided any of the materials in your document production today directly to Dr. Ross.
Correct.
Have you prepared any report in Dr. Ross's case?
Yes.
What is your report?
I've prepared a lot of reports that are outlined throughout this book of evidence to a lot of people that goes towards Dr. Ross's damages. So there are a lot of reports, there are a lot of letters, there are a lot of minutes to meetings. I created a model of what took place on the Witch Creek fire. I recreated a YouTube video so the public could see what started the Witch Creek fire.
What reports have you prepared specifically for Dr. Ross's case? Not for the fires in general, but specifically for Dr. Ross's case.
I have not prepared any reports. My conclusions are based on my findings and what I understand about her business and my review of her personal assets.
Summarize your overall findings regarding damages in Dr. Ross's case.
The overall damages for Dr. Ross are number one, I have concluded and will offer the opinion that Dr. Ross sustained 100% loss of her personal belongings. I have concluded that Dr. Ross has lost all of the information and database surrounding her business from heart rate variability database. And I have concluded that Dr. Ross has lost the ability to live in her home, enjoy her home, and live a productive life in her home because of San Diego Gas and Electric. So the punitive damages associated with that is something a jury has to decide. And a jury has to decide that based on the malicious acts, the intentional harm, the intentional disregard for public safety by a public utility whose chartered fiduciary duty is to protect the public. And in this case, they don't care. So the punitive damages associated with their acts will have to be, that's not something that I can assess, so I can't put a number on that, if you will.
Let's go off the record for a brief break.
This marks the end of media number 1 in the deposition of Edward L. Clark. Going off the record, the time is 11:21 a.m. This marks beginning of media number 2 in the deposition of Edward L. Clark. Today's date is May 20th, 2016. Back on the record, the time is 11:31 a.m.
During the break, Mr. Clark, did you speak with Dr. Ross?
Yes, I did.
What did you speak about?
She actually reminded me, and I didn't know when you asked me the question, that she actually, this cover sheet that's in my discovery, she actually gave that to me.
What
Just that
exhibit
page.
is that?
Under 42. It was just mixed in with my work, and I just forgot.
It says Equus on
Yes.
top of it?
Yes, apparently that's the magazine that she had some information in.
Did you and Dr. Ross discuss anything else during the break?
No, she just was concerned that I misrepresented that, so she wanted me to tell you.
Let's next mark exhibit number 4256. Mr. Clark, if you could take a look at exhibit number 4256. On top it says the electrical expert, forensic analysis, and expert witness. Then below that it says experience.
Okay?
Do you recognize this document?
I don't know. This might be it almost looks like it's off on my website, I think.
Okay.
I'm not sure I've ever seen this document like this, so I don't recognize it.
Okay.
But that is a picture of me on there.
This document comes from theelectricalexpert.com.
So my website, okay?
Your website is theelectricalexpert.com?
Yes.
Are you the electrical expert?
Yes, I am.
Is this document a copy of your current CV?
Like I indicated earlier, on the CV I gave you, I'm the CEO of a title insurance company. That's not on the CV that I gave you. So USA National Title Company.
But it is on this document, correct?
But it's on this one, correct?
Okay.
And I mentioned that to you when you questioned me earlier.
Is the content of this CV that we're looking at right now fully accurate?
It looks pretty close. I'd have to look at it compared to what I gave you today, but I think it came from the same document.
Take a look at it. Let me know if there's anything that's not accurate in it.
No, let me compare it to let me just pull the other one up real quick. Just look at it. Oops, where's it at? The classification for expert witness isn't on this one, on the one that you gave me, Exhibit 4256.
Okay.
And this one you gave me also has been added expert witness testimony under employment history. Oh, this one's on here as well. It's just in a different spot, okay. I mean, it's a different format, but the information looks pretty consistent.
Okay. So am I correct that the content of this document we're looking at right now, your CV, is fully accurate?
Well, you know, when you use the word fully accurate, I'm not sure if you're looking for something that's not in here. As I indicated earlier, you know, I'm testifying as a damage expert on this case because of its electrically caused fire. Does the word damage expert say in there? It's contained in the elements that are on this resume. So if that's what you're looking for, then I just need to point you in that direction.
Is there anything incorrect that's on this CV?
Not that I'm aware of.
What is your experience as what you call a damages expert?
I've been testifying as a forensic expert on electrically caused incidents since the middle 90s. And on many of those cases, I would have to assess the damage associated with who was at fault. So, I mean, that's just been a part of being an expert witness. But as long as it was an electrically caused incident, then I would testify on those issues. If it was not an electrically caused instance, I would not let somebody retain me, quote unquote, specifically as a damage expert. So my background and credentials have to do with electrically caused incidents, exclusive testing background, and so in those cases, then I would assess damage in combination.
In those cases you're talking about, how specifically did you look at damages in those cases?
It depended on the client. and what the request was. For example, if there was an electrocution case or an electrical related accident where a piece of equipment failed and blew up, I would look at the damages associated with that failure and who was at fault and assess the cost and what the damages were.
You would assess the cost?
Yes.
How would you do that?
I would assess, in a case where, for example, a substation blew up. Substations have a lot of pieces to it, so an entire substation would blow up. It's rare that you have catastrophic failure, 100% loss like you do in this case. So I would take a look at the details of an inventory, what failed or what got burned up, and assess the cost as a construction contractor. So I would, in a lot of cases, determine what it would cost to put it all back together. Not necessarily do the work, but assess if somebody was fair or not fair, or, in a case where somebody lost valuables, I would have to rely on them saying what valuables that they lost, and let somebody else decide if that's legitimate or not.
Prior to this case, have you ever offered an opinion as an expert on the value of personal property lost?
I think I have. Yes, I have. Yes, I have.
What were those cases or case?
For example, I did a case up in Northern California, but I had to do some research a long time ago, for example, in a mobile home park, that a trailer burned completely to the ground because of the incoming line from the utility. And because that was caused by the utility, I assessed the value of the loss. And the way I assessed the value of the loss was the cost of the mobile home was an easy number to obtain to replace the mobile home. And then the valuables that were internal into the home were provided to me by the lawyer I was working for, and it was just part of the damages. Okay. Because in that case, it was provided by the homeowner who had a record of what they had in the home. So it's very similar to this one, actually.
Am I correct that the value was provided to you, you then looked at that value and decided it was reasonable?
In that particular case, I did, as I did in this case. In that particular case, it was interesting because it's very similar to the whole mobile home burned down. I had another case that involved a tract home that the whole home wasn't burned down. And so in that case, I couldn't make a determination that it was 100% loss because there was obviously stuff still there. So there was some dialogue that went back and forth as to what was reasonable, and so decisions were made based on that. So when it comes to 100% loss, somebody has to recreate what was in the home, and a jury has to decide if it's reasonable or not. All we can do is put the number out there and make that determination if that's what the number is.
In that second case, did the client provide you with a personal property list?
The client provided the attorney I was working for. I didn't have any direct communication with the client here. Normally, Dr. Ross is representing herself, so that this is a little bit of a unique situation that doesn't happen very often. So in that case, the attorney provided me the list, and I created my opinions based on the list, because it was an electrically caused incident.
On that list, am I correct that there were values attached to it as well?
Yes.
Okay. Then you looked at the list and decided if it looked reasonable to you or not?
In that particular case, you're talking about the one that was a partial one or the one that was 100% burned down?
We can do the partial one first.
Well, in the case of the partial one, I just questioned the attorney as to the things that we could put our hands on in terms of the construction costs of rebuilding the tract home. The electrical panel was completely destroyed. The incoming line from the utility was completely destroyed. The car was completely destroyed. So there were tangibles that as far as the actual, like for example, a car got burned up, and the value of that car was something that was provided to me. It looked reasonable to me. I bought a lot of cars, so I didn't do the research to go back and determine or contradict any of those types of costs, as I have not done with Dr. Ross. I relied on the information provided based on what was in her home and what those values are. I don't have anything to dispute that. They look reasonable to me. And I did the same thing in those cases.
Okay. Meaning you did not do additional research, but instead focused on looking at the materials provided to you and determining whether those looked reasonable?
Well, no, I don't want you to put words in my mouth because that's not exactly what happened. What, in the case of 100% failure, like in this case, there's no additional research to do. I can see that it's 100% gone. In the case where it was a partial house burned down, I looked at the areas that were burned and the things that were on the list and made a determination if it was legitimate or not, or if they were just adding stuff or throwing it. I mean, we all have homes. We all know we have a TV. We all know we have a stove. And I mean, you kind of have an idea of what is legitimate and what should be in a home. And I know what's in my home, and there's a lot of money tied up in my home. So you got to look at things with an open mind, and there's no way to go back and recreate those things because they're dust. So you have to rely on the information provided you to some degree to see if it seems reliable or not.
Let's next mark exhibit number 4257. Exhibit number 4257 also says the electrical expert, forensic analysis, and expert witness on top. Then underneath that it says areas of expertise. Do you recognize this document?
I haven't looked at my website for so long. I'm assuming you got this off my website.
Correct.
Yeah, I recognize it. It looks like it came from my website. As I indicated, I haven't looked at my website for several years.
If you could read through this document silently and then let us know if everything in this document that has been stated is correct.
Okay.
Is the content that is stated in this document fully correct?
Yes, it is, especially this part that it says electricity is simple, common sense goes a long ways, and anytime he offers an opinion, he can prove it. Yes, it is.
This document is a page from your website, correct?
It appears to be so. Counselor, as I indicated, it's been probably a good couple, 2-3 years since I've looked at my website, but it looks like it was from my website.
Your website is entitled The Electrical Expert, Forensic Analysis, and Expert Witness?
Yes.
When did you start that website?
I started that website following my involvement with the 2007 Witch Creek fire, specifically for the purpose, once I realized SDG&E was going to cover this up, it was for the purpose for me to have a location to put my work online so people could track what was going on down there. It was a way to try to get public exposure.
Let's turn now to your education. You have a Bachelor of Science in Electrical Engineering from Long Beach State.
Yes, I do.
When did you obtain that degree?
Now, I'm going to date myself I think I got, well, I don't know if it's laid out in here, but I'm going to estimate around 1984, I think.
Do you have any other educational degrees?
Actual degrees, no.
Certifications?
Well, while I was working with Southern California Edison Company, you know, I got certified through their apprentice electrician program. I got certified through their operator school. I got certified through their testing program. I then became an instructor and got certified by them to be their instructor. So, you know, those aren't actual certifications, but I got pieces of paper for them, but not from a university.
Anything else?
I think that's it in the electrical world.
What about in terms of other educational degrees or certifications?
Well, I carry securities permits all over the state of California because of my title insurance company. I have licenses in every county. There's just a lot of securities issues associated with that I require certifications. So, I mean, that's a different mechanism. I don't think it's relative to this case, but they are certifications.
Anything else?
Not that I can think of right now.
For your employment history, you began work at Southern California Edison Company?
That was my first electrical related job, yes. I was actually a sheet metal machinist prior to that, and worked at a mobile gas station and McDonald's as a kid through college, so there's other miscellaneous stuff that I didn't think was important to identify.
Okay. You worked at SoCal Edison from 1980 to 1990
Yes.
as a maintenance electrician?
Amongst other things, that was one of the classifications. You left off a train of work-related stuff while I was there. I was a maintenance electrician for a short period of time.
Then a test technician?
Correct.
Then as a division engineer?
Correct.
Okay. All of this work related to SoCal Edison's electrical services?
It related specifically to my background at the Edison Company was electrical testing and maintenance and prediction of failures.
Did you perform any other work at SoCal Edison?
I mean, I performed a lot of things at Southern California Edison because as a division engineer, I had all the testing personnel as direct reports to me. So I was the person that they called when a decision had to be made based on their test data, very similar to this case as Dr. Ross. So I had, I think, 8 different test crews throughout a large service territory. And I would set up their testing programs, and the same thing that happened in my company, ELC Electric. It was the same format where they would go out and perform tests, and if there was a piece of equipment that looked like it was getting in trouble or a decision needed to be made, you know, some of these transformers could be $1 million, $2 million, $3 million huge, they're size of homes. So to make the decision to pull something out of service when it doesn't look from the outside like anything's wrong, similar to a racehorse, I was the guy that made that decision based on my databases and all the history and my professional career. So that's what my expertise was from specifically Southern California Edison Company.
Right.
And then I went on with that with ELC Electric and performed the same service for the public.
Right. Did you found ELC Electric?
Yes, I did.
What year was that in?
The year I left Southern California Edison Company, I think it was September. In fact, specifically, I think it was September 15th, 1990. It was my 10th year anniversary with the Edison Company. But I actually, when I founded it, was actually, I think I obtained my contractor's license officially 6 or 7 months prior to that, in preparation of getting ready to leave.
Okay. What is ELC Electric?
ELC Electric is my initials, number 1, Edward Leroy Clark. And it was founded as a specialized high voltage testing company for testing apparatus throughout California.
Okay. How long were you at ELC Electric?
I founded that in September of 1990, and I believe I shut that company down officially in 2005. I started the progression in 2003.
What was the reason to shut it down?
I got divorced in 2003, and I'd made a lot of money, and I didn't want to give half of it to my ex-wife, so I shut the company down.
Any other
I didn't
reasons?
mean to offend anybody, but that was the primary reason I had at the time. I think I got up into that company about 350 employees. It was substantial. So I was at a good point in life to kick back and take it easy and see what else I was going to do. And so that's the reason I shut that company down and just really moved forward with expert witness litigation work.
What did that subsequent expert witness litigation work focus on?
It was a whole array. I specialized in primarily utility-related cases. I seem to be one of the few experts out there that would testify against a public utility. I've learned the hard way, quite honestly, that all these engineers, when they retire, and all these people go work for the utilities, so they won't testify against them. I didn't have a problem with that, so I really started out doing a lot of work for Sempra Energy. Started out doing a lot of testimony for Southern California, not so much Southern California as a company, but like some municipalities. I did some stuff for the city of Vernon. I don't recall all the places, but I did a lot of work at the time for Sempra Energy. And then once I took a case against Sempra Energy, I no longer really have done any testimony for a utility. It's been all against a utility.
Approximately when did that shift happen?
I'm going to say in about, I know there's a huge case in San Jacinto I did for Larry Davis, and that was probably, boy, you're going to test my memory, at the late 90s. And in the late 90s, they called me up and put me on a case where an airplane had crashed into a high voltage transmission line up off the 15 freeway. And because of my specialized ground protection background, which is exactly the reason I know what caused the Witch Creek fire, that airplane crash caused explosions in about 6 different places throughout California simultaneously. And once I connected the dots, that was the last time, and explained, and I was working for Sempra, the gas side, and I informed them, the utility, this is just devastating for any public utility for this to become public knowledge. They immediately took me off that case. I never worked on it again, and I never heard from them again. So as a result of that one, I wouldn't go along with a cover-up, so the best thing to do was to get me off the case and not have me get involved.
Right. You founded USA National Title Company in 2006.
USA National Title Company?
Yes.
That's when the doors actually opened. I started the process. The first original applications went to the Department of Insurance in 2003, which is when I started the shutdown process of ELC Electric. It just took me till 2005 to get all the documents through government agencies and just finally to where it was shut down because of all the 401k plans and stuff. So it took 2 years for that process. So at the time I decided to shut down ELC Electric, I made the decision to get engaged with the title insurance business and started the process to get licensed. And it took me till 2006 to actually get the doors open.
What type of work does USA National Title Company do?
It's a title insurance for residential and commercial properties and settlement services.
Approximately how many employees are at the company?
Well, I don't know that that's really relevant for this particular case.
I'm asking about your experience here, and if you're heading up an organization that's relevant to it.
I have about roughly 50 people in that company. I don't work there, but I'm going to say, as far as that company is concerned, I'm relatively semi-retired. I have somebody that runs that company for me. But so when I say approximately 50, I'm not there all the time, so I don't know the exact numbers. I don't pay attention to that stuff. That's what somebody else does. So,
okay. Do you own USA National Title Company?
Yes, I do.
100%?
No, I have a couple of minority stockholders. I have a couple of minority partners that were required by the Department of Insurance for me to get licensed. Back in the days when I was getting licensed, if you recall all the savings and loans failures companies, the Department of Insurance would not issue a license to a single person because you're managing millions of dollars of other people's money. So they required me to have a silent partner, so I got 2 brothers that are friends of mine. And then I have a couple key employees that are very small, minority partners, but I own the majority stock.
Okay. Who are the minority owners?
A gentleman by the name of George Adams and Terry Adams. They don't have anything to do with the company. And then there's a gentleman, Greg Snyder, who's one of my key salespeople, and another gentleman, Nick Pappas, who's the president of the company. He runs the company.
You're the CEO of the company?
Yes, I am.
Other than working at USA National Title Company and performing expert witness work, do you have any other current jobs?
I sure try not to. I'm trying to retire. Nothing I can think of.
How many current cases are you consulting for?
I think the only one I have left is this one. I think everything I've been working with in the past is pretty much off the table now. I think everything's settled. I think right now, currently, this is the only case I have.
Okay. Over the past year, how many cases have you consulted for?
I'm going to say, well, there's a difference between consulted and actually being retained. So I'm going to say I've had probably a dozen phone calls where I've advised people on whether they have a case or not. That's what happens usually. I will say 90% of the time they don't have a case against the utilities. The utilities usually have pretty reputable people with integrity, and they're usually doing things the right way. So since I get consulted with on primarily utility cases, I'm going to say out of those dozen cases, I'm trying to think if I think I got one retainer. So out of a dozen cases, I probably got one other retainer besides Dr. Ross, that once I did a little bit of an analysis, it didn't go any farther because there was no case.
How many cases have you been designated as an expert on?
Since I've been doing expert testimony, well over 100. A lot. I'm guessing on how many. I totally guess how many, but I'm going to say estimates somewhere between, and I think I've used this before in deposition, somewhere between 100 and 150. I don't really know the number because I don't track them. I don't create a resume and show all my cases because it's just not important to me.
Were all of those cases in California?
No. No.
Approximately how many of those cases were outside of California?
10%, probably.
What states would those have been in?
I've been to Arizona, I've been to Washington, I've been to Oregon, I've been to New York. I've been to quite a few places, actually.
Have you ever taken any courses in accounting?
I'm sure I did in college.
Do you recall taking any courses in accounting?
I don't think when you're saying course, I'm referring to a college course. I don't recall a specific course title. I mean, we had economics classes where accounting is involved. We had business economics, which involves accounting classes. So yeah, I'm going to say yes in college. And then when I started ELC Electric up, when you're the owner of the company, you better understand how to read a P&L and how to manage money. So there was some books I had obtained and read up on how to create a balance sheet, because when you're an engineer for a big utility and you're fresh, you don't know how to do those kinds of things. So if you're going to start a company, you have to educate yourself. So I took some courses that you buy through the mail and just read the books and took the tests, and that kind of thing. Okay. That's how I basically started out.
You are not a claims adjuster, correct?
No. For Southern California Gas Company? No.
No. Just my question is, you are not a claims adjuster, period, correct?
Is my title a claims adjuster? If I have a specific title, no. Am I a claims adjuster? Can I evaluate a claim and can I come up with a number? Absolutely, all day long. Better than most.
Have you ever served as a claims adjuster for any organization?
Well, yeah, I think that as an expert witness, a claims adjuster in determining losses, like what we're talking about here, is the same thing. I mean, you might call it claims adjuster, but determining damages is the same thing. That's what a claims adjuster does. He determines what the damages are and what's reasonable and what's fair. It's the identical same thing. I don't have a title, a business card that I can give you that says claims adjuster, but yeah, absolutely, I do claims adjusting in most cases I get involved with.
What prior experience equips you to do that?
My experience at Southern California Edison Company, my experience at ELC Electric, in getting involved as a contractor in determining what a claim is good or not, how much something's going to cost to repair, my testimony on many cases as an expert witness, my testimony, quite frankly, with Larry Davis of Sempra Energy on cases I did with him, evaluating the losses that he was exposed to. So as an expert witness, in my specific field that has to do with electrical high voltage equipment and utilities and testing, I do a lot of analysis on claims adjusting. I've been doing it from day one.
Have you ever been employed by an insurance company?
I own an insurance company. So I am a claims adjuster for my insurance company in that world. I call myself a chief executive officer, which means I can do everything underneath me, and I'm the guy that deals with all the legal aspects of claims against my company. So the final decision on a claim comes from me, so I guess you can call me what you want.
Is it your testimony that USA National Title Company is an insurance company?
It's USA National Title Company is a title insurance company in the world of real estate. That's exactly what we do. We insure real estate transactions. You must not know what that is because we went over that earlier. So let me share it with you. What I do is if you're going to buy a house from me, you have no idea what judgments, claims are against me in the legal world, but yet you want to own my home. So you put your money up to a third-party company as what we call escrow or settlement services, which is what my company does. And then we go through the transaction. So myself as an insurance company investigates me, in this case, investigates claims, judgments, encumbrances, and insures to you and to your bank who's loaning to your money through an insurance policy that when you give the money through the transaction, when you move into that home is yours. So if anybody comes down the road later out of the woodworks, family member tries to claim stake to your house, I insure that and I have to protect that claim. So that makes me a claims adjuster.
Have you evaluated the value of personal property as part of that position?
No, because not in that position, because it's strictly real estate transactions, deeds, that kind of a thing. That doesn't have to do with a claim that somebody's lost all their personal belongings because they sold a house. That's not what we insure. We insure the property itself, the deed on the property. Does
Dr. Ross have a claim for real property in her case?
Dr. Ross has a claim for personal property, and she has a claim for she's got personal injury claims, and she's got, or is going to have them or whatever, and she's also got punitive damage claims.
Okay. Do you know why she does not have a real property claim?
She was a renter there, and under the the one thing that we know that are facts is that she had a right to the property because she was a renter, and it goes back to she doesn't have, just because she's a renter doesn't mean she didn't have access to the property. She had a full right to the property. She had the right to enjoy that property. She had a right to conduct her business out of that property. And those are all the elements that SDG&E prevented her now from being able to do.
In what way?
They burned her house down.
Okay.
And they burned her house down when they should have prevented it back in 2003.
Was Dr. Ross insured at the time of the fire?
I understand she had a business insurance policy that your client apparently settled with the insurance carrier, and they have failed to pay her. So there's an issue with business insurance that I haven't really gotten too involved with, other than a general conversation that's a whole nother issue. But somehow your client SDG&E paid that claim prior to the claim being finalized. And the insurance company hasn't paid her. So that's an issue that I'm not testifying on. I'm just sharing with you the conversation that I had with her.
So you are not offering an expert opinion on insurance-related issues?
Not on that particular case, because I just learned of that through my conversation this last week, and I haven't had an opportunity to investigate it, and nor have I been asked to offer an opinion on that. Now, does that mean I don't know if it's too late for her to do that? That's something between her and you and me and whatever. I'm not sure.
Okay. You are not an appraiser, correct?
Do I have the title of an appraiser? No. Do I have the ability to value properties as an appraiser? Yes.
How so?
Because I own a title insurance company. And one of the things that we do is we support, for example, appraisers that get retained by the bank. I provide all the property profile information and comps on homes and I can call up a property and tell you what the property values are based on the size, the square footage. If you live in a harbor, the dock size. I have a lot of tools at my discretion that I pay for as a title insurance company that I give to my employees so that they have the ability to do just that and work and help appraisers.
Are you a certified real estate appraiser?
No, I'm not.
Are you a certified personal property appraiser?
I'm assuming when you say certified, do I have a piece of paper that says I have that? The answer is no.
Have you taken any courses in personal property appraisal?
Yes.
What were those courses?
I'm going to call it the course of life. I'm 57 years old. I know exactly how much stuff is that I pay for on a day-to-day living in my own home. I've been running companies. I know how much desks are, tables are, all kinds of stuff. So if I've gone to school for it, I'm going to say yes. I've spent my entire life learning what's reasonable and what's not.
Anything else?
No.
Let's next mark exhibit number 4258. Mr. Clark, if you could take a look at exhibit number 4258. On the front, it's entitled Plaintiff Christine Ross's Designation and Exchange of Expert Witness Information.
Okay.
Have you seen this document before?
I don't think I have.
If you could turn to page 7 of the document, do you see where it says number 4, Edward L. Clark, Jr.?
Yes.
If you could silently read that section covering you and let me know when you're done with that.
Okay.
To the best of your knowledge, is that section fully correct?
Well, this is what I planned on testifying on. Is it fully correct? Did he leave anything out? I think as long as we include the fact that the damages encumber putative damages, we're not just talking about personal property. We're talking about personal property, business, punitive damages, and damages associated with personal injury, then it's okay.
Have you offered an opinion as to personal injury damages that Dr. Ross has faced?
But you haven't asked me yet.
Have you formed an opinion on that?
Yes, I have.
What is your opinion on it?
My opinion is based on my knowledge in the brief encounters I've had with Dr. Ross, to the extent of the harassment nature by which you guys, by the way you guys have gone about this case and treated it, she is an emotional wreck. She has been diagnosed with some ailments that has required a lot of money and doctor's visits, and I realize that stems not just from the 2007 Witch Creek fire, but it starts from back at the 2007 or 2003 Cedar and Paradise fires. So the types of mental anguishes and stuff that she's been experiencing goes back to 2003. So I have formed the opinion that she should, if she hasn't, I don't know what she's claimed on that issue, but she should get all of her medical bills recovered and paid for and compensated for what your client, San Diego Gas and Electric and Separate Energy, has intentionally put her through by failing to fix a problem they've known about since 2003.
Has Dr. Ross claimed medical bills as part of her alleged damages?
I don't know. I have to go back and look exactly to see what that is. I'm just making an opinion based on what I have seen from her and my experience with her, and she can barely get through the day. She's been an emotional roller coaster during this time frame that I've met her. So,
do you know one way or the other if Dr. Ross is claiming past medical bills?
I have to go back and read what's in the mediation brief. I have to go back and read what all is in there.
Are you a medical doctor?
No, I'm not.
Is it your testimony today that you're qualified to opine on Dr. Ross's alleged personal injuries?
I'm surely qualified to discuss and offer an opinion on my experience with Dr. Ross and what I feel she's going through and how the difficulty she has dealing and coping with the losses that San Diego Gas, Electric, and Separate Energy has caused her. And the law, anybody can understand that what somebody goes through if they have 100% loss caused by somebody else, and they try to not take care of them, pay for it, reimburse them, etc.
Is that a lay opinion that you're offering?
No.
Is that an expert opinion you're offering?
That is my opinion with a lot of experience as an expert witness in dealing with tremendous emotions with people who have gone through similar situations. So I am not a doctor per se. I'm not a credentialed doctor, but I can surely offer an opinion based on my experience and what she's going through, and based on how I know I would be if I lost the same information, because I fully understand her business. I mean, if you're out of business and you go broke overnight and you had a very successful thing going on, everybody handles things different. She's been very difficult, had a very difficult time.
My question is, are you offering an expert opinion on any personal injuries that Dr. Ross allegedly suffered?
I have not seen an outline on any specific personal
No,
injuries.
this is a
alleged.
yes or no question now. Are you offering an expert opinion or not? You have a lay opinion or an expert opinion. You've said that you're not offering a lay opinion on it. My question to you is, are you offering an expert opinion on any alleged personal injuries incurred by Dr. Ross?
I'm offering an opinion, and I'll let you interpret if it's a lay or an
No,
expert.
that's not the question. Are you refusing to answer it one way or the other?
Yes, I am, because I explained to you the basis of my opinion, and quite honestly, you're a lawyer. You can figure it out. If you don't like my answer, I'll leave it up to you to interpret it. But my answer is this: that my experience with Dr. Ross as her electrical expert reviewing damages, I can see for myself what she's going through, my experience with her, and she has personal injuries that need to be taken care of. So that is my opinion.
You consider yourself an electrical expert, correct?
Yes.
What does the term expert mean to you?
It means that I am offering an opinion based on my experience that can be utilized in court to present an opinion so a jury can evaluate the facts of the case and make a determination on the value, the final number on what that is. So my expert testimony is based on my experiences. You don't have to be credentialed. You don't have to be a doctor. It can be based on your experience as long as you have the experience to substantiate it. And I am here to tell you, I have dealt with a lot of people as an expert witness who have gone through, they've lost, I mean, I get involved with electrocution cases where people get killed, for crying out loud, so I'm dealing with tremendous emotion, all of which I see in Dr. Ross. So I do have the qualifications and the experience to testify to the fact that she has tremendous emotional distress, whatever that means. That's for the doctors to make that final conclusion. But I am here to tell you and offer an opinion that my experience with her, she needs help, and she needs to be taken care of.
Is that an opinion you intend to testify on at the damages only trial?
If I get asked the question, I'll be happy to offer my opinion.
Is that opinion included as part of the expert opinions that you've generated in this case?
It is included in the opinions that I have offered in this case. If I get asked that question based on my experience with Dr. Ross, that's the opinion I'm going to give.
Okay. What are the expert opinions that you've formed in this case as opposed to some other opinions? I'm trying to differentiate these now because you've been designated as an expert in this case.
Right.
You've not been designated as a lay witness or anything like that. Am I correct? You're not a lay witness in this case. Is that right?
I'm designated as an expert witness.
Expert
Correct.
witness. So the only purpose of your testimony at trial would be as an expert witness, correct?
Well, that's really up to the lawyers presenting the case. They can ask me whatever they want, and whatever question I get asked, I'm going to answer.
What opinions have you formed in this case that do not involve expert opinions?
I haven't really thought about that because I've only thought about what I'm going to talk about, my official expert opinions.
Are all of the opinions that you have formed in conjunction with your involvement in this case tied together with your expert opinions that you have formed?
Yes.
Okay. What opinion or opinions have you formed as a purported expert in this case on Dr. Ross's business losses?
That she has a 100% loss and deserves to recover all of her future business, all the claims that she's indicated for her business by itself. She has, my opinion at trial will be that you destroyed her business. You've prevented her from moving forward. You've basically put her out of business. So my opinion at trial is she has a 100% loss.
Have you based that opinion on reviewing Dr. Ross's mediation demand?
No.
What is that opinion based on?
That opinion is based on the fact that her business is exactly like mine. I have tremendous experience in the world of sophisticated electrical testing. Her testing is the same application, similar, a little different because of her specific niche, but in my business, put myself in the same shoes, it would have put me out of business too. So when you have a niche in the market and you're on the leading edge, the value of that is enormous. So when I look at her business, I mean, she didn't have to tell me much about it. I got it because I've lived it and I understand it. And I've almost gone, I've been in situations where all of a sudden somebody tried to take something from me and I almost failed. So I understand the emotional anguish and the loss of money and all of the things associated with her losses. So those are the basis of my opinions on why she had a 100% loss, and that I think her demands for her losses are reasonable.
What do you allege to be the monetary value of Dr. Ross's lost income in this case?
I'm going to rely back to the mediation brief where it's outlined on the amounts that she laid out. The document speaks for itself. I'm not going to recite it from memory, but my opinion on that issue is that she has a 100% loss. And that's the fact in the case, that she has a 100% loss. The final number will have to be determined by a jury.
Okay. You found the claimed amount regarding Dr. Ross's alleged business losses in her mediation demand to be reasonable?
Yes.
Okay. Do you know how much revenue Dr. Ross generated from any HRV business that she had?
I don't have the data. I don't have, in answer to your question, I relied, my testimony is based on the mediation brief and the data that's in the mediation brief. I didn't go through and in my mind specifically, so if you asked me to recall something from memory, I don't know. Her and I she had a discussion about that, but I don't really recall the numbers, because right now for me, that wasn't part of my opinion. The document that she provided in her mediation brief speaks for itself.
Are you aware that Dr. Ross has submitted discovery responses in this case?
I haven't seen them.
Okay.
I need to object.
Am I correct that?
Excuse me, I'm objecting to this because there's a problem with that question. And you know what that problem is, counsel.
Dr. Ross, if you have an objection, state it on the record.
I have an objection. I object.
Okay. Am I correct that you have not reviewed any of Dr. Ross's discovery responses?
That's correct.
Okay. Am I correct that you have not reviewed any of the deposition transcripts in this case?
That's correct. And I'll point out there's not any deposition transcripts that would influence me or change my opinion. My opinion is based on my personal experience with this case. I've been involved with it since 2007. My personal experience with a business almost identical to Dr. Ross's. So I understand there were some depositions, and just because I didn't want to waste my client's money, I told her I didn't need to see them. My opinions are mine based on my experience and my knowledge of what's going on in this case.
So my objection is you are referring to unverified discovery responses.
I'm referring to all discovery responses by Dr. Ross
Which
in this case.
are not all verified. That's my objection. You are asking questions about something that you have not obtained verification for. That's my objection.
Thank you, Dr. Ross. Let's next mark exhibit number 4259. Exhibit number 4259 is entitled Plaintiff Christine Ross's Designation and Exchange of Expert Witness Information. These are the supplemental expert designations made by Dr. Ross. Have you seen this document before, Mr. Clark?
No, I have not.
If you could, Mr. Clark, refer to page 4, which says Declaration of Christine Ross, DVM on top.
Okay.
Do you see the section entitled Edward L. Clark, Jr.?
Yes.
That would be paragraphs 2 through 4. If you could just read that silently to yourself and let me know when you're done.
Yes.
Okay. To the best of your knowledge, is everything contained in paragraphs 2 through 4 of Dr. Ross's declaration correct?
Looks like everything's fine to me. Are these going back to the court reporter?
Yes. Let's go off the record for a minute, and I'll see if we have anything left.
Going off the record, the time is 12:26 p.m. Back on the record, the time is 12:34 p.m.
Mr. Clark, am I correct that in generating the expert opinions that you've generated in this case, you've relied on each of the documents that you produced today?
Yes, I have.
Okay. Are there any documents other than those that you've produced today that you relied on informing your opinions in this case?
I don't think so. I think I've produced everything that was asked for and the basis of my opinions.
Okay.
I do have a little bit more discovery to do that prior to trial, and I guess I don't know how you handle that, but I've got I just recently came across the realization that the governor's sister is on the board of directors. So just out of curiosity, I'm just really curious to do a little bit more investigation on whether or not if it's going to be subject for testimony or not, whether or not, I'd love to find out how much SEMPRA has contributed to Governor Brown financial campaign. Same thing with the president, the Democrats. So, I'm piecing the puzzle together with how super PACs have all these politicians in their hip pocket. So I'm going to do a little bit more discovery on trying to tie down the understanding of why, when so many people have been put on notice about what's going on down here, nobody in government would take a phone call. So somehow there's a correlation to all the way up to the top office. It's somehow, some way, SEMPRA is strong enough to where you get the President of the United States looking the other direction. So I'm really curious to see, I don't know how I go about finding out how much money they make in their political contributions, but that is something I'll just let you know that I'm interested in finding out, just from my own personal understanding of our political system. And I just don't understand how politicians who are in responsible positions can look the other way and not get involved because of somebody so powerful like SEMPRA Energy. So I just want to share with you, that's just some other discovery I want to do, and I don't know if it's going to be allowable at trial or not. I'm just letting you know I'm doing that.
How does that relate to the damages-only trial for Dr. Ross in this action?
It'll go towards punitive damages, and the reason for that is because at the end, when a jury hears the dots connected of how far-reaching SEMPRA's influence is, and the fact that they have intentionally disregarded public safety for so many years and killed so many people because of their conscious disregard, I think the punitive damages will be heavily influenced by the jury fully understanding the state of mind of everybody involved.
Those are all the questions I have for now. Dr. Ross, do you have any questions?
I do. Do you want to trade places?
Yes, we can do that off the record when we do.
Oh, and off the record, the time is 12:37 p.m. Back on the record, the time is 12:39 p.m.
Mr. Clark, were you served with a subpoena that included a production of documents by SDG&E for today?
Yes, I was.
And does that include tabs 1 through 47 in these two?
Yes, it does.
Okay. So the binders and the documents shown to counsel are responsive to that subpoena
Yes.
served on you? Okay. Are the documents produced today intended to support your assessment of damages as a result of the wildfire known as the 2007 Witch Creek Fire?
Yes.
Have you testified, and are you considered an expert in electrically caused fires?
Yes.
Have you been retained by SEMPRA Energy as an expert to assess cause and origin and liability on electrically caused fires?
Yes.
Are all the documents you produce utilized to support your assessment of damages in this action?
Yes.
Are the documents today intended to argue liability as defined by opposing counsel?
No.
Objection. Calls for speculation.
Okay. The answer to that was no.
Thank you. Are the documents today intended to support your assessment of damages as a result of intentional infliction of emotional distress?
Yes.
Are the documents today intended to support your assessment of damages as a result of nuisance?
Yes.
Are the are the documents produced today intended to support your assessment of damages as a result of trespass?
Yes.
Are the documents produced today intended to support your assessment of damages as a result of negligence?
Yes.
Are the documents produced today intended to support your assessment of damages as a result of intentional deceit?
Yes.
Are the documents produced today intended to support your assessment of damages as a result of intentional misrepresentation and fraud?
Yes.
Are the documents produced today intended to support your assessment of damages as a result of intentional acts of SEMPRA, SDG&E, and its executives to have conscious disregard for public safety?
Yes.
The documents produced today contain 47 tabs. Can you go through and explain each of them and how it pertains to this case? in your assessment of damages?
Objection, vague and ambiguous.
Yes, I can, if you would like me to.
Yeah, could you do that, please?
I think the best, and I can answer this in a generic question since it's already been asked and answered by counsel.
Okay.
Or I could sit and go through each one, but the tabs 1 through 47 have been compiled as, in each case, as the overview to show and demonstrate the state of mind, the fraud, the deceit by Sempra executives and SDG&E. So all the documents together are inclusive of my opinions and form the basis of my opinions for trial testimony. Now that's was asked and answered, and does that answer your question? I think I can go through each individual and talk about each one, or I can just, as a generic, I think it's similar to what he did. Is that adequate for you?
That will be fine.
Okay.
That will be fine for now. But yeah, it is. Mr. Clark, have you had meetings with the PUC? Excuse me.
Yes, I have.
And when were those meetings?
I've actually had a couple of them. Let me see if I
I'm
can
going to
find
object. Once again, SDG&E objects to this and other questioning and testimony regarding the causation of and or
The
liability
PUC.
regarding. Dr. Ross, please let me finish. SDG&E objects to this and any other questioning and testimony regarding the causation of and or the liability regarding the 2007 San Diego wildfires. Those topics are not at issue in the upcoming damages only trial and are not at issue in this deposition. SDG&E reserves all rights to question Mr. Clark about causation and or liability issues at a separate time. SDG&E further objects to being charged for any of Mr. Clark's time spent on non-damages related testimony in this deposition.
Okay, are you finished?
Yes.
Okay, this question relates to damages.
Can you ask the question again,
Yes,
please?
this question relates to damages. So we're clear. To be clear, this question relates to damages. Have you had meetings with the PUC?
Yes, I have.
And when were those meetings?
The first meeting I had was with the California Public Utilities Commission was up in Los Angeles, January 16th, 2008. And then shortly after that, I had a subsequent site investigation meeting with Steve Antabli of the PUC and showed him where and how the fire started. And the reasons those documents are in this file, as it goes to the extent of the knowledge of people associated with knowing how the Witch Creek fire, all the people involved that have looked the other way, and it goes towards, so definitely go towards the total effect of punitive damages when it's presented to a jury, how far-reaching Sempra Energy's influence is. So it goes to the state of mind and the control that Sempra has over the Public Utilities Commission and CAL FIRE as well.
I object to this entire line of questioning, as well as any questions in subsequent testimony and prior testimony in this case that involves causation or liability regarding the 2007 San Diego wildfires. We've now heard multiple times that Mr. Clark's purported opinions in this case have to do with what he calls punitive damages. Punitive damages are not at issue in the upcoming damages only trial in this action. The upcoming, let me finish again, Dr. Ross, please. The upcoming damages only trial in this action involves Dr. Ross's specific claimed damages in the fire. That includes damages such as personal property damages. It does not include damages such as punitive damages, which would be argued at the subsequent liability trial in this action. Therefore, I object to this entire line of questioning and any of the responses that are provided.
These questions involve intentional infliction of emotional distress. These
Dr.
involve, let me finish, Mr. Vandal. I let you finish. This involves nuisance, trespass, annoyance, and discomfort. Those are part of a damages only trial.
Dr. Ross, as you know, you no longer have an emotional distress claim in this case.
Annoyance and discomfort.
You said intentional infliction of emotional distress. You do not
I
have
have
an emotional
annoyance. I
distress
have
claim in
annoyance.
this
I
case.
have
Sorry, one at a time, please.
I have annoyance and discomfort under trespass.
Okay. None of this questioning has anything to do with your annoyance and discomfort damages. Once again,
Okay.
I am making this objection on the record. I'm not going to continue making the objection, but we object to any of this questioning regarding liability or causation related issues, and we further object to any sort of charge being made to SDG&E for payment of Mr. Clark's time for testimony about these issues
Okay.
that have nothing to do with the upcoming damages only trial.
You have requested documents from a psychiatrist and a psychologist. So if you are wasting my time and expense, that will be brought up as well. So there are documents being requested from a psychiatrist and a psychologist.
Yes. Dr. Ross, those documents have been requested because you listed those individuals as your experts in this case. We asked you, and I'm not going to go into this further because it has nothing to do with this deposition, but we explicitly asked you if you were willing to de-designate those individuals as
I'm not.
experts, and if you did that, we would not have subpoenaed them. You
So
did
I'll-
not even respond to
So
that.
I'll continue. I will continue. In your opinion, why did you think the PUC didn't disclose your work
Well, why did they not?
in their public report? In their public report.
Because I think now I think that they were directed not to from the influence from Sempra Energy, primarily with one of their board of directors, who's the sister of the governor of California, who has influence over CAL FIRE and PUC.
Okay. And so, have you had meetings with CAL FIRE?
Yes, I have.
Okay. And you shared with CAL FIRE your information and your opinion.
Yes.
Of what was related to the damages at my property.
Yes.
Okay.
Well, let me back up. At the time I met with CAL FIRE, I had not met you yet.
Yeah. Okay. So.
Okay. So in terms of my knowledge, the reason why I've included CAL FIRE and the PUC, and I'm going to comment a little bit on council's objection, the reason why it is significant and the reason why I've included it in my damage analysis is because your annoyance and discomfort claim comes with punitive damages when it's shown that the acts of the party, meaning Sempra, has gone with complete disregard of public safety. CAL FIRE is a public entity, PUC is a public entity. Both have full knowledge of what started these fires. Both refused to meet with me and Larry Davis. Larry Davis refused to schedule a meeting with me. So the reason why that information is contained and embodied in my ultimate decision is so that when it comes time to the punitive damage phase of your damages trial coming up on annoyance and discomfort, a jury can see the extent and the far-reaching influence Sempra Energy has on the PUC and CAL FIRE.
Once again, I object to this entire line of questioning and the responses. Punitive damages are not at issue in the upcoming damages only trial.
Okay.
They simply are not. The court has made that very clear. And all of this testimony and the related questioning here today has to do with alleged knowledge by SDG&E, alleged involvement by SDG&E in the cause of the fire. None of that has anything to do with the upcoming trial.
Okay. Are you finished?
May I ask one real quick question? On the record, what time is it, just in case there's an issue over who's paying for what, so I can document it?
We'll go back and figure that out. I don't have
It's
the
on her
time right now.
Okay.
Okay.
I'm going to take a real quick check and just write it down, just because I know what you're on the hook for here. Excuse me just one second. I'm going to turn on my phone so I can write the time down so that there's no dispute here when we get done today. Does the court reporter have the time?
12:51.
Thank you. I don't have to do this. Oh, there, I just got it. Thank you.
Okay. So let me go back. In your opinion, the reason why CAL FIRE did not disclose this? What was your opinion as to why CAL FIRE did not disclose this?
It's my opinion that CAL FIRE was told not to disclose the cause of the Witch Creek fire, that they were fully aware. They had all the information, they had pictures, they had the test results. So it was my opinion that they were directed not to by Sempra Energy's and SDG&E's political influence over them.
Okay. And you made several requests to CAL FIRE and the PUC and SDG&E to meet with you. What is your opinion of why they refused?
Because Larry Davis specifically is the mastermind behind preventing my testimony from becoming a part of all the testimony before all the cases settled. I understand there's only a couple left out of the thousands of cases.
Mm-hmm.
And this was SDG&E's way of defending and reducing their liability, was to try not to let this come out. So that's why it happened.
And did you make a request for those meetings? You made a request for meetings?
Many times, yes.
Okay, Mr. Clark, you have a distribution list of government employees to whom you sent a copy of your book.
Yes.
Did you get a response from anyone in the government?
No, I did not. I did not so much as get one phone call.
And do you have an opinion as to why you didn't receive a response from anyone in the government?
My opinion is that the political reach of Sempra, a Fortune 500 company, a super PAC, if you will, goes to the top office in California and definitely to the top office in the current administration.
Okay, so do you have an opinion regarding, that SDG&E has influenced any concealment of this information?
Objection. Once again, we're going into
I'm almost finished here.
allegations regarding liability, causation, issues that are completely unrelated to the damages-only trial in this action.
I'm sorry, is there a question pending?
Yeah. What is your opinion of why SDG&E and Sempra have influenced the PUC and CAL FIRE?
Again, I'll tell you the biggest reason. There's several reasons actually. So I'm just going to name them. The SDG&E is currently in front of the PUC to try to get a rate increase to have all the citizens in San Diego pay for what they cost.
Yes.
Number one. Number two, they've gone down this path because A, they don't want to be on the hook for killing the people that died. I mean, should be a criminal investigation. Number three, they're doing this because they don't want to expose the same problem that happened in 2007 as they falsely prosecuted a lost hunter on the 2003 Cedar Fire, which was caused by the same design, which is also in this book, as well as the Paradise Fire in 2003. So where on one hand, in 2003, they might have, if they would have been professional and just taken care of the problem, and if it would have come out what caused these fires, it would have been negligence at that time. But since 2003, I have witnesses that know for a fact that SDG&E knows this was a design problem and didn't fix it. I have, it's imperative to understand that it's going to open a can of worms for SDG&E if this information goes back, because there's no statute of limitations when people die. So the problem with 2007, when this is realized, the knowledge SDG&E Sempra has, it's now an intentional conduct. So the damages for you as a plaintiff in this case are far greater in 2007 because of the damages that will be assessed because of their state of mind, their intentional acts to deceive the public, their intentional act to deceive government agencies, their intentional acts to hide this from everybody involved.
Again, I object to this entire line of questioning and the responses. All of these allegations about state of mind are completely irrelevant to the upcoming damages-only trial.
I believe we're finished. You did bring something with you. Did you want to refer to?
No, I think I've done everything I could.
Okay.
I think
Thank you
we're
very
good.
much. I'm finished.
I have no further questions, but let's do the stipulation regarding the transcript. Mr. Clark, should we transmit the transcript to you directly
I think
for your review?
that would probably save some time. I don't know what your folks' timing is on things coming up, but you can send it directly to me and I can review it and get it right back to Dr. Ross.
Let's go off the record real quick to see how long it'll take to do the
I
transcript.
don't think
Off the
we-
record? Off the record?
Why would we need to do this off the record?
Because I need to talk to the court reporter about how long it will take her to do the transcript. Off the record?
Apparently, that's fine.
Going off the record, the time is 12:57 p.m. Back on the record, the time is 12:59 p.m.
So an original of the deposition transcript from Mr. Clark's deposition will be mailed via FedEx to Mr. Clark by Friday, May 27th. Mr. Clark, if you could state on the record what address the FedEx envelope should be sent to.
Yes, send it to my attention at 5582 McFadden Avenue in Huntington Beach, California, 92649.
Mr. Clark has then agreed to review the transcript, make any necessary corrections to it, and then send it back with those corrections by Thursday, June 2nd. Is that correct, Mr. Clark?
That's correct, and I'm presuming that I'll get a copy of the DVD so I can listen to it while I'm reading as well at the same time.
No. You'll receive a copy of the transcript.
When will I get a copy of the DVD?
You do not get a copy of the DVD. If Dr. Ross wishes to separately order a copy of the DVD, she may do so
Would you
and
please?
send that to you.
Absolutely.
Would you please do that? So you can put on the record that you ordered a copy?
I will.
Hang on, one at a time, please.
I would love to order a copy, please. Thank you.
If for some reason the original of the transcript is for some reason not returned, a certified copy of the transcript will be used as if it was the original. So stipulated?
Quick question before you do that. I'm going to send the original back. Will you send me a copy as well, or do I need to make a copy? Can you send me? Are you going to send me the original and a copy of the original?
I believe only the original will go to you. You should make a copy.
Can you order a copy to be sent at the same time so that I have a document? So if there's any changes, I can reflect them in a copy.
Absolutely. I will order
You
a
need
copy.
to ask her for it.
May I order a copy of that too, please? Thank you.
Dr. Ross, do you stipulate?
I do.
All right, thank you. Off the
This-
record.
This concludes today's video deposition of Edward L. Clark. Total number of media used is 2. Going off the record, the time is 1:02 p.m.